going to have to bear with me. I forgot my spectacles at home, and I'm blind as a mole without those things, so it's going to be a bit of a struggle. You are a Western Cape native. You were born and bred in Cape Town.
That's correct, Chief Justice. I grew up in what is known as the Cape Flats.
And you studied there,
That is
naturally. And you obtained a BA Law and LLB from the University of the Western Cape.
That's correct.
And a while later did an LLM with the University of Cape Town.
That's correct, Chief Justice.
What was your thesis on?
The topic of my thesis was restorative justice in the context of juvenile justice.
All right. You did not stop there. You obtained a certificate in labor law from UCT and a diploma in insolvency law and practice from the University of Pretoria.
That's correct.
I'm sure those qualifications came in handy in your practice.
Indeed, Chief Justice.
You joined the site, but you did your articles between 1988 and 1990, then became a professional assistant in another law firm.
That's correct, for 9 months.
And that 9 months was enough to build up the courage to start your own practice.
Well, Chief Justice, I was effectively running that practice, and that motivated me to start my own practice.
Yes. And you ran a solo outfit for 14 years.
That's correct, Chief Justice. Post articles, I have practiced as an attorney for 15 years. 14 years, I was the sole proprietor of my own firm.
All right. Doing what kind of work?
Well, initially, being a woman at that time, the opportunities for commercial work, etc., was quite limited. So I initially started out doing criminal work, and I sort of called myself a GP, a general practitioner, that would include administration of estates, doing criminal work, which was the larger part of my work, and then the run-of-the-mill legal work such as interdicts, spoliation orders, eviction matters, everything but complex commercial matters. And I took whatever came on my table.
Yeah, as we all did.
Yes.
You were permanently appointed in this division you seek to lead now in 2006 already.
That's correct, Chief Justice.
But you had acted as a judge before.
I've acted as a judge, that's correct, first in the Northern Cape, 2 terms in the Northern Cape and 1 term in the Eastern Cape. Currently, 2 months from now, my period of service as a judge would be 19 years.
In which seat of the Eastern Cape Division did you work?
I worked in Port Elizabeth as well as Grahamstown, which was the seat of the appeal court in Grahamstown.
Right, I did not know that until I read your papers. Okay, and you have acted at the Apex Court?
I have acted for 1 full year in the Constitutional Court, that's correct.
How did you find that experience?
It was quite an experience because I was exposed to hands-on experience of the transformation agenda of our Constitution. And it made me more alive to the situation in South Africa, human rights, socio-economic conditions, and the mandate of the Constitution and its transformative agenda. So it was a very, very enlightening and educational experience for me.
Yes. But then you refused my invitation to act at the Supreme Court of Appeal.
At that time, it wasn't a suitable time for me due to personal reasons, Chief Justice.
Yeah, no, I'm just, I never forgave you for that.
There's still opportunity for me in the future, Chief Justice.
Indeed, you still have a lot of time on the bench. 10 is it 10 years?
That's correct, Chief Justice.
All right. you've done a lot of things. You've managed to find time to write articles that were published in the midst of your busy job and family life and everything else.
That's correct, Chief Justice. I was quite busy in my younger days. I was quite energetic. You will note that I sat for the notary exams, I sat for the conveyancing exams.
Oh yes,
Yes.
you were admitted as conveyancer
Yes,
and
I-
notary public
I
as
did.
well.
Yeah, I was quite energetic at the time, Chief Justice.
But then you were writing as recently as 2016. You'd been a judge for 10 years then, but then you stopped.
I stopped because I had to focus more on my judgment writing
Yeah.
and speak through my judgments. But I would like to resume writing because there are many things that one can write about.
Yeah. Well, you've written many judgments in the 19 years
I did.
on the bench. I'm not even going to go there on all aspects of the law. You've been very active. Well, you've been involved with a number of organizations, but notably the South African chapter of the International Association of Women Judges, of which you were an executive member for 2 terms.
That's correct, Chief Justice. I started out at Nadal. My principal was Essa Musa, who was one of the founder members of Nadal. When I started my articles there, I immediately became involved in Nadal. That is the organization I've been attached to, I think, the longest. And then 5 years before my appointment, I was with BLA. And then, of course, as a judge, I became active in the International Association of Women Judges, where I served as treasurer for 2 terms. That translates into 4 years.
Okay. You've been in a leadership position in that court for a number of years. When were you appointed as Deputy Judge President?
The 1st of June 2016, Chief Justice. I'm currently Deputy Judge President of the division for 8 years, and I've been acting as Acting Judge President 2 months, short of 2 years. So it's
Alright.
10 years, almost 10 years in total.
Okay. It's public knowledge that that court is notorious for being troubled, for use of a simple term. And in fact, one of your contenders has mentioned that morale is low, and he says one of the things he would like to achieve if he is appointed is to create an environment where judges can work, speak, and just go about their way without feeling intimidated. And then there is a statement that raises a number of concerns that was submitted to the Judicial Service Commission by one of the senior judges there, Judge Ali, who lists a number of things that she says are concerning about your leadership style and the measures you have implemented, which she perceives as ruinous to the running of the court. How are things there, really? And just how are things there, and what do you have in mind to put them right if these accounts are true?
Chief Justice, short of 2 months, I have been leading that division for almost 2 years. When I stepped into that position of acting judge president, the division was in a dire state. There were no judges' meetings held for a period of 6 years. The tea room was non-existent. The morale of the judges were low. So yes, it was very challenging for me initially when I took over this division. I immediately introduced mechanisms to make the environment more conducive for judges to operate in. And Chief Justice, I can categorically say that if there is a judge who says that the division is troubled as I sit here today, that is not a correct statement to make. I've introduced judges' meetings upon my appointment Judges are free to air their views. Judges are free to place matters on the agenda. This was mentioned in Judge Ali's comments that she's made, but I will get there later. The division is not a division where no one is talking to each other, where no one is performing, where people are, where there's mistrust and unstable environment. I think if there's anyone who says that the Western Cape division is in disarray, it is an incorrect statement to make. I have worked very hard and I have put mechanisms in place to make the environment conducive for service delivery, and I believe that I did that with the best of my ability. There has never been any bad publicity about the Western Cape High Court in the almost 2 years that I have been leading that division. So, if a judge says that that judge feels uncomfortable in that division, and that division is not running properly, and that that judge does not have a voice, it is an incorrect statement. My chambers is open. I have an open door policy. And Chief Justice and Honourable Commissioners, let me inform you as follows. Not a single judge came to my chambers to come and complain about anything. And for any judge to now at this stage make submissions to this august body that the division has problems, I am very surprised to hear that. I have an open door policy. Anyone can come and see me at 9:30 in the morning without an appointment. But let me go back to when I took over this division. I immediately called the judges' meeting. I informed the judges, we are all alive to the history in this division. And I am now assuming this seat, and we must now go on a project of healing in the division. And I allowed all the judges to articulate how they feel, what they think we should do to improve the running of the division, what mechanisms we can put in place, and we had a very productive meeting. My words at the start of that meeting was, let's have a conversation. So, Chief Justice, I dispute any statement that's trying to create the perception that that division is not functioning efficiently, effectively. If there is a judge who may have an issue, it was not raised with me. We have regular judges' meetings. I reinstalled the tea room specifically to further and to encourage collegiality in the division. The tea room was non-existent when I took over the division. The tea room is flourishing. We have a regular judges' meeting. We are communicating with each other. Judges are free to air their views, make suggestions, etc. With regard to Judge Ali, I have responded to those submissions, and I am quite happy to respond to each and every aspect that any commissioner feels I should respond to. All I can say is Judge Ali is not in leadership. She is not aware as to how my office functions and the processes that is in place. And if there's any specific aspect that any commissioner would like to clarify with me, I am most welcome to do that. But let me take one aspect that she's raised in her submissions that she has made. She talks about expedited dates, implying that I am creating a system of preferential treatment in certain matters, and alluded to the fact that I can be swayed to expedite matters. And then thereafter she states that my strategy, the manner in which I allocate expedited dates, impacts on judges who are attending to semi-urgent and urgent matters, in the sense that if a judge decides a matter is urgent or semi-urgent, and I can interfere by providing expedited dates, I would imagine bringing those dates forward or interfering with urgent and semi-urgent dates. Honourable Commissioners, that statement is entirely untrue. An expedited date has got nothing to do with urgent dates or semi-urgent dates. But when one reads those comments, it can create the impression, why would AJP give people expedited dates alongside the concept of semi-urgent and urgent matters, but there's no connection between the two. Honourable Commissioners, an expedited date is exactly what it is. There's already a trial date allocated to those matters. So as an example, hearing date could be scheduled for the 10th of February 2025, and the parties, and that is all the parties in the matter, may approach the Office of the Judge President to expedite that particular date. It has got nothing to do with urgent matters. People can apply for urgent dates in the normal course. The judge on urgent duty deals with those issues. Semi-urgent dates, they can go to the 4th Division clerk for a semi-urgent date. But expedited dates, which falls within the prerogative of the Judge President, is done as follows. All applications for expedited dates must be in writing, and it must be at the request of both parties. As I've alluded to earlier, the date may have been scheduled for February 2025, and what the parties then do is they jointly approach the acting Judge President to bring the date forward, and that is on that basis that a matter can then be expedited if there are legitimate grounds for that. I have been doing it as the acting Judge President for many years, and there's no magic to it. There's no fixed criteria, obviously, but it can be for many reasons, and both parties must seek and apply for the expedited date. So it is done in writing. It is a paper process. I don't see anyone, and it is assessed on its merits, on paper. It can be any reason. For example, one of the parties will be immigrating, or it involves a child, or someone is very ill and frail, or very elderly. There are many scenarios. That's why there's not a fixed list as to when you allow expedited dates. So, Chief Justice, just on that score, and you've alluded to concerns raised by Judge Ali, I just needed to clarify the fact that expedited dates, semi-urgent dates, and urgent dates are entirely separate issues.
Well, she does raise other concerns,
Yes.
Ranging from an allegation that whilst there are judges' meetings, no minutes are taken there, so it's difficult to keep up with what resolutions were taken, to the more serious that the system of the continuous role, which the importance of which we know too well, has been prejudiced by the manner in which, the measures you have put in place, causing delays in work output. And then there is another concern, another serious concern, the general impression, in fact, that one gets from this submission, that the judges there do not have a voice, really. You impose your views and decisions upon them. You don't consult. That's what comes out of this.
Chief Justice, the last statement, I'm the one who introduced judges' meetings. Judges are free to place any items on the agenda, and that is how we've been running. I have an open door policy. I'm most certainly not a dictator. I can reassure this commission any judge can come and raise any issue with me. I did not actually get the impression that she was saying that judges don't have a voice in her comments. The fact of the matter is, I re-established regular judges' meetings. I re-established the tea room to promote collegiality, and any allegation that judges don't have a voice, I must refute those allegations. It is most certainly not true. With regard to minutes of meetings, Chief Justice, since 2010, no minutes have been taken at that meetings. I've made submissions on that regard. I was the last scribe of judges' meetings. A resolution was taken in 2010 that no minutes will be taken any longer. Judges should be free to express themselves. I have made written submissions on that point, that I requested the Judge President to stand down because I was the official scribe, and a judge was designated, a female judge, and then a debate ensued as to why only female judges should take minutes. The debate ensued, and Judge Ali was very vocal about it, and ultimately a decision was taken not to take any minutes in judges' meetings. That was 2010. So since 2010, no minutes were taken. But when I assumed my position as AJP, I took it upon myself to record my notes. I wouldn't call it minutes, it's my notes, because ultimately as a leader you must make notes as to the way forward and which matters should be actioned, etc., etc. This statement that there are no record of minutes and recordals of decisions taken, that is entirely untrue. I was the scribe last in 2010, and I'm still the scribe, Chief Justice. I'm still the scribe, because as the leader, you must know, you must action things. Some matters are referred to the practice committee. By the way, I also established the committees. There was no committees when I took over the division on the 14th of December 2020, so I re-established the tea room. I restored the meetings, and I then also re-established certain committees, the IT committee, building committee, library committee, etc., etc. So, commissioners, picture this. You have the freedom to air your views, to place a matter on the agenda. You have the freedom to air your views and say what you want to say and make proposals. In our very first meeting, the proposal came out. We only have 40 matters on the motion court roll. Let's increase it to 100 matters. That was at our very first meeting. Who says judge? How can judges say they don't have a voice? And we implemented that. And if there were any other issues, we would decide how to action it. It would be referred to the building committee, it would be referred to the library committee, or it would be referred to the practice committee in terms of how we action matters, or it would be something that management will raise with the chief registrar or with the director of court operations. Chief Justice, I can reassure this commission, there are indeed a record of each and every meeting that takes place there. It may not be visible to others. I was the last scribe, and I am still, in my capacity as AJP, still keeping minutes in that meeting. Then, with regard to a continuous role, the continuous role is very much alive in the division. But Chief Justice, we all know what happened to that continuous role during the COVID era. When I took over as the acting judge president on the 14th of December 2022, more than 80% of the judges were involved in crime. Only 20% of the judges were available for civil allocations. 80% of the judges were part of the criminal backlog project. Now, what do you do as a leader when 80% of the judges are all busy with crime? What happens to the civil role? What happens to the continuous role? How do you navigate your way around that? 80% of the judges in crime. And the 20% who were seized with civil matters were bearing the brunt of civil matters, and they were all overloaded with civil matters. They hardly had any space in their diaries. 20% of the judges had to carry that load, and Western Cape High Court has a heavy civil load. So with 80% of the judges in crime, 20% of judges busy with civil, Chief Justice, the reality is there cannot be a continuous role. The criminal backlog project obliterated the idea of a continuous role, and I had to navigate my way around that. So if anyone tells this commission, writes to this commission and says that the AJP interfered with the functioning of a continuous role, it means that they don't have an understanding of the state of the division. I did an audit of the state of the division when I assumed the position of AJP. And with 80% of the judges in crime, it was very difficult to maintain a continuous role with only 20% of the judges in crime, in civil. The idea is to allocate a matter and let one judge take the matter to its completion. That is the idea. But honorable commissioners, when I say 80% of the judges were in crime. You must understand that those 80% of the judges did not only deal with one criminal matter. They had more than one criminal matter each. And when I took over that division, the number of part-heard criminal matters that had to be completed in piecemeal fashion for various reasons. If one judge was in the criminal backlog pool, had 3 part-heard matters to attend to, they then had to align their diaries with defense counsel, with the state attorney, and align the diaries with the result that those part-heards were completed in a piecemeal fashion, which further obliterates the idea of a continuous role. The idea of the continuous role is an ideal in a normal situation where the court is functioning normally and where there are no backlogs and where you don't sit in a situation where 80% of the judges are seized with crime and you have a small number of judges who can then proceed with civil matters. So, Chief Justice, this idea that I ran this division not according to a continuous role, there's no merit in that. One must be alive to the realities of the situation following the COVID-19 pandemic, and our division is currently still dealing with the aftermath of that in terms of the finalizing of our criminal matters. The Western Cape High Court cannot, at this stage, have a fully functional, continuous role until we have achieved a certain level of completion with criminal matters, which we have now done in this last term.
All right, point taken, AJP. But just to go back to the first part of my question about my impression that you don't consult your colleagues there. This submission pertinently states that you fail to circulate timeously to your colleagues reports, discussion documents, and resolutions requiring their input, and it lists a number of examples and mentions something quite worrisome, that you do not ask the judges for their inputs at heads of court meetings, and they are not given feedback on decisions taken at that forum.
Chief Justice, I have responded to that allegation. Judge Ali mentioned a specific meeting and what had happened at that meeting. That meeting was specifically called to give feedback on what happened at a heads of court meeting. I actually call special meetings for the judges to attend. And not all the judges attend all the time. I don't think Judge Ali attended all the meetings. But I specifically call judges' meetings, and then I call separate meetings to give feedback on what other issues are of concern. I have responded to that complaint, Chief Justice. There was an allegation that I didn't circulate the first rationalization report. I've responded to that allegation. That was under the leadership of Judge Traverso and Judge Lope. That allegation is not true. There was an allegation that I did not circulate the second rationalization report. I've provided proof of that. It was circulated to all the judges. There was an allegation that I did not circulate resolutions at the judges' conference to the judges. I have circulated those resolutions, and I have provided proof of that. Chief Justice, I think this allegation of me not communicating with judges and not circulating documents, I reject that allegation with the contempt it deserves, because one of my strengths is communication, and I am an inclusive leader. I'm a collaborative leader. There is absolutely no way that I would not circulate documents to judges. And for Judge Ali to make the statement after our judges' conference that I did not circulate the resolutions, I've provided the Commission with proof that I've circulated it. That in itself, it's an incorrect statement. And I would like to ask the Commission to view that statement with caution, because the exact items she mentioned that I did not circulate, I provided the Commission with proof thereof. And I do discuss important aspects as to what happens in the heads of court meetings. regarding issues that affect the judges, whether it's the benefits, motor vehicle benefits, cell phone benefits, and issues with regarding recesses, leave periods, etc., etc. I do, and I had those type of meetings. And Honourable Commissioners, those meetings where I discuss matters that would be addressed at heads of court, I involve the admin management also in those meetings. They also sit in those meetings because budgetary issues comes up. Tools of trade is discussed. Benefits, judges' benefits are discussed. And it's important for the management, and I'm saying management, I'm talking about the management who would be responsible for the budget of the court. It's important that they are there. Or if there's a shortage of staff, which was also an item that we have discussed at heads of court meeting, I raise all those issues in the meetings that I call special meetings. The special meetings would be things that's not just within the division, but things that impacts on the judges. So, Chief Justice, that statement that I don't consult is incorrect, the statement that I don't circulate is incorrect, and the statement that I don't report on what happens at heads of court meetings are incorrect. And Judge Ali, in her own complaint, referred to a meeting which was specifically called to report on what had transpired in a heads of court meeting.
Thank you, AJP. Now, you've mentioned a number of measures you say you have put in place since you took over that have worked to get the division back on its feet, helped it recover from the bad condition in which you found it when you took over as acting judge president. Is there still any room for improvement in the operations of the court? And if you think there is, what ideas do you have?
Chief Justice and Honourable Commissioners, I'm not here today to only talk about what I can do for the division. I am here to talk about what I have already done. I have a track record. I almost ran that division for 2 years. I have a track record. Chief Justice, when I took over that division, the Director of Public Prosecutions were not allowed in the building for some reason. The Director of Court Operations were not allowed to enter into that building. And when I assumed office, that is the first two people who came to see me. The National Director of Public Prosecutions informed me she's not allowed to enter the building. She must work through the Chief Registrar. If there's anything she wants to discuss regarding crime, she must speak through the Chief Registrar. And that hampered service delivery because there were no meeting between herself and the leadership to discuss the criminal backlog. I am aware that a senior judge was designated to be in charge of the criminal backlog, but that judge also did not liaise directly with the NPA. So I am mentioning this because this is one of the bad things that I found when I started, when I took over the division as AJP. The Director of Court Operations were only allowed to attend certain meetings. So they were the two first people who came to me, and I immediately restored their access to the division, and I later on, we communicated with each other, and the NPA is obviously part of the stakeholders that I regularly consult. So that was also one of the first things I did, was consulting all stakeholders, be it the family advocate, NPA, the legal profession, LPC, etc. I have given an indication of what I have done, but the most important thing to remember is that there was no handover in that division. So I assumed the leadership of the division without any handover, and I was on my own, and I ran that division on my own for one full term. I did a wellness check, and I discovered 324 files that needed to be actioned, with correspondence as far back as August 2022, and I had to action those matters expeditiously. I did a wellness check, and decided to run the division on my own the first term. And I utilized that strategy because in my capacity as Deputy Judge President, I had the necessary know-how to know how the division should run optimally. But the point that I'm making is the division was not in perfect shape at the time. No tea room, no stakeholder engagement, people were banned from the building, no regular meetings. And I had to restore and work with all those aspects. When I assumed the position as AJP, the lead time of cases were, that was in the 14th of December 2022, the closest date that you could get a civil matter on the roll was two and a half years from that date. 2.5 years from that date. I arrested that date with mechanisms that I've put in place. So, Chief Justice, I've mentioned some of the things that I have done. So I've spoken about the restoration of the committees. I've spoken about our meetings. I've involved judges in the running of the division, and some of the judges who are going to present themselves here today, they are members of committees. Judge Dolari is dealing with the building and management, as well as Judge Mantami. Judge Slingers is involved in HR, in the practice committee. Judge Ali herself said that she was involved in training acting judges. There's not a single judge who was left out. And if judges don't have a voice, Chief Justice, I wonder why they would get involved and sit on these committees. That is not true. They were actively participating in structures that I initiated and put in place. So, Chief Justice, your question is, what did I do? Can I just get clarification? Because I can itemize what I did do.
No.
Or is it what new I would like to do?
I was asking if you still think there is room for improvement on the operations of the court, and if there is, what are those? What ideas do you have to get the court in better shape?
Chief Justice, currently the Western Cape Division is drowning in paper. In my view, the court is functioning quite in a stable manner. The court is fully functional. You can never say a court is functioning optimally because there's always room for improvement. But the Western Cape Division is drowning in paper. So what is needed desperately now, and the most efficient way to improve the Western Cape Division currently, is through digitization. So with regard to digitization, all the staff have been trained, the judges have been trained. We are currently busy embarking on reaching out to other stakeholders, grassroots community members, and any person that you could think of, LPC, the Bar Council, the profession, the man in the street. We are busy embarking on consultation with stakeholders to provide training to them. So the entire court is trained, stakeholders will be trained. We are currently in the process of finalizing our practice directives, and then we will embark on the registration of all the parties and stakeholders, and we hope to go live on 1 December this year. That is the most pressing need for the Western Cape High Court, is to digitize the court, and that is work in progress at the moment, Chief Justice. With regard to the case flow as such, I have introduced mechanisms to increase productivity. I've indicated that when I assumed my position, I observed that the Friday appeal roll there were very few cases on the Friday appeal roll, sometimes just 3 or 4 cases. There are 33 judges. That would mean that you would have 3 judges in motion court. That would leave 30 judges who needs to be allocated on a Friday. And if there are only 3 cases, that would then keep 6 judges busy. And I immediately introduced a system where opposed motions are also now heard on a Friday to make the court more productive. I've also introduced a pro bono project. Many years ago, there was a pro bono project, but I introduced the pro bono project, not only limited to Fridays, but to any day whenever pro bono counsel is available. And that is to be understood against the background that 80% of the judges were involved in crime. So I needed the necessary assistance, specifically in the civil pool, and I made use of the pro bono resource. So what happened then was that the number of opposed motions, the finalization rate in terms of our stats increased dramatically because you had judges hearing opposed motions on a Friday, which could be 20 judges, as I've just indicated, and you have pro bono judges hearing opposed motions. So the biggest impact in terms of stats during my stint as the AJP is in the number of opposed motions that virtually trebled compared to previous years. I also established the RAF court that deals specifically with RAF matters. And the purpose of that court was to try and mediate some of the disputes, try to minimize the issues, and try to facilitate early settlement of RAF matters. And that specific court dealt with PRASA and RAF matters as well. And then, of course, there's the issue of damages, medical negligence matters that could also be mediated in that court. And I myself, I am involved in mediating family matters and medical negligence matters in order to see whether those matters can be settled out of court. So the RAF court also had big impact because many of the matters became settled, and that resulted in vacant slots for other matters. And then what the project that I then introduced was, where RAF matters were allocated in a specific slot, we then approach the profession, and where matters are postponed a year or so later, we give them an opportunity to fill those slots. In other words, we brought matters forward, and that arrested the lead time of matters in the division. From where I sit here now, if a civil matter, if you require a civil trial date, we are looking at the 12th of August, 2025. If you are looking for a semi-urgent date, we're looking at January 2025. An urgent date is even sooner. So our lead times currently is excellent. For civil trials, it currently is 8 months, but the goal is to get our lead times in 6 months. So the RAF project increased productivity, allowed us to bring matters forward and to increase our stats. The Friday project plus the pro bono project also increased productivity in the division and increased our stats insofar as opposed motions are concerned. With regard to crime, the division currently have 33 parted criminal matters. Last term, 16 criminal matters were finalized, and we currently have 33 parted matters, of which 14 of the matters are in sentencing stage. So if you take the 16 matters last term that was finalized, plus the 14 matters that is in sentencing stage, we're looking at 30 matters by this term, 30 matters would have been concluded. So there is an improvement in the finalization rate of criminal matters. Chief Justice, I did mention in my papers that I have introduced the RAF directives. I have also introduced the criminal directives, and through implementation of those directives, the court became more productive, and I streamlined processes with the RAF court and with the control of the criminal courts, the criminal directives that also improve the efficacy of the court. Thank you, Chief Justice.
Thank you, AJP. So, in sum, all's well as can be in the Western Cape Division of the High Court, and it only faces the challenges that the rest of our courts have.
Yes, Chief Justice, I want to reassure the Commission, I am the Deputy Judge President of that division. I've been trained. I have been fully trained by the former Judge President. The former Judge President was my mentor. And for me to step into the position of AJP, it cannot be correct if any judge wants to create the impression that I don't know what I'm doing and I don't know what's going on and judges don't have a voice. Quite frankly, that is not my personality. So, Chief Justice, to answer your question, it is correct. The Western Cape Division has normal challenges, lack of resources, shortage of staff, in need of building maintenance, sometimes the aircon doesn't work, in need of more judges, and in need of more courts. And on assumption of my position as AJP, and as I've indicated to the Commission, I have institutional memory. And as the saying goes, you must know where you come from to know where you're heading to. So I am very alive, and I've always been very alive to the fact that we need additional courts at the Western Cape High Court. And when I assumed my position as AJP, I immediately put mechanisms in place to achieve that goal for additional courts for the Western Cape High Court. So I've put mechanisms in place and motivated for the additional courts. And on the 24th of August this year, my request was approved. So it is a short-term project, short or medium-term, 2 to 3 year project. The Public Works approved the addition of 3 new courts for the Western Cape High Court, plus a record room. Chief Justice, my answer to your question is yes. There's nothing unique in the challenges that the Western Cape High Court face. The court is functioning, judges are talking, meetings are held, judges can air their views freely, and the challenges facing the Western Court is nothing more than challenges that would face any court, and that would be lack of resources, lack of space, too few judges, and then the question of digitization of the court. Thank you, Chief Justice.
Thank you, AJP. Judge Gamble, do you have questions for this candidate?
Yes, thank you, CJ. AJP, just a couple of nuts and bolts issues before I ask you a few more probing questions. Your CV shows us that you turn 60 tomorrow.
That's correct, Chief Justice.
So how much time do you have left to offer the division? Effectively 10 years, but you could go earlier if you wanted to.
I have 10 years, but I could leave on 65 if I want to, yes.
So the provision that you leave at 65 would mean that you could offer a minimum of 5 and a maximum of 10.
That's correct, Commissioner.
I'm looking at the list of acting judges at the moment, and I see that at present, the division has 14 acting judges in position.
That's correct.
There are actually more than 14 judges. Some of them share a term, but there are 14 slots for acting judges.
That's correct.
You've also lost a number of experienced judges over the last couple of years, and another one to go shortly.
That is correct, Commissioner. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, and with one retiring shortly to be 12. The division lost in the last, 3, 4 years, 12 judges to retirement. There are currently 4 vacancies. Yes, the pool of the skills pool and the experience pool of the judges is depleted at the moment, busy depleting.
Now, I'm looking at the list, the current list of acting judges. You probably have it there before you. You've sourced acting judges from all over. Would you perhaps like to speak to that? I see that you've even sourced judges, acting judges from Gauteng and I think Limpopo.
Yeah.
Would you like to speak to that?
Yeah, I just can't find my list. I'm just checking if I can lay my hand on it.
I can give you the list if you
can.
like.
Yeah, you can give me that list. But what I can say is, I source acting judges from the profession, from stakeholders, and names are put forward. And then in consultation with the deputy, we would then invite acting judges. The idea is to make the pool as diverse as possible. And what we have experienced was that we were struggling to find capable black acting judges to act in the division. So resultantly, what I did, I went wider than the Western Cape High Court in order to make sure that the appointments are diverse. And yes, I have approached, I think, 3 African women outside of the province to come and act in the division.
Now, there's an issue that the Chief Justice raised about division and disharmony in the division. I think you need to place that in context. I don't think you've given the Commission the proper context in relation to which that division arose, because it's something that many of us have lived through. You were appointed in 2016. At that stage, the applicants for Deputy Judge President were yourself, Judge Ali, and Judge Lachranji.
That's correct, Chief Justice.
The Judge President at that stage, the former Judge President at that stage, was happy to have you and pushed for your appointment, as I understand it.
I was appointed as the Deputy Chief Justice in 2016, and Judge Ali was also a contender for the position.
What was the relationship between yourself and the former Judge President at the time of your appointment in 2016? Your working relationship?
The former Judge President and myself had an excellent relationship, working relationship. In fact, we had different leadership styles. He mentored me, he trained me, and I provided the necessary support to the former Judge President. I can safely say that there were no issues between us, and we complemented each other, and the division was well run at the time.
According to your CV in 2018, you spent the year at the Constitutional Court, the full year.
That's correct, Chief Justice.
And while you were away, was there an acting Deputy Judge President appointed in your place?
That is correct. It was Judge Desai.
When you came back from the Constitutional Court, you reassumed your position as DJP.
That's correct.
And then at the beginning of 2020, I think it was January 2020, you took the extraordinary step of laying a complaint against your Judge President. And that received a lot of publicity at the time, and a lot of people were critical about what was going on in the Western Cape. I think you need to explain to the commissioners what the context of that complaint was.
Judge Campbell, no, we're not going to go there. Some of these matters are still subject to adjudication by the Judicial Conduct Committee and perhaps the Judicial Conduct Tribunal. And quite apart from that, I don't think it would be right to ask the candidate about things which concern someone else who's not before us to answer for themselves. So please just desist from that line of questioning.
Very well, Chief Justice. After that complaint was lodged, what was the relationship between yourself and the former judge president like?
Obviously, it impacted on our relationship. Chief Justice, I heard your directive that it is not necessary to go too much into detail surrounding what had transpired then. All I can tell the Commission is that I was a complainant and I lodged a complaint, and subsequent to my complaint, a counter-complaint against me was lodged. The matter went through the necessary processes, and ultimately a decision was made by this body as to what should happen to that complaint, in terms of which I was exonerated. I'm referring to the counter-complaint. But if I could answer Judge Gamble's question, yes, the division, there were tensions at the time after I lodged the complaint, and would like to indicate to the commissioners, and I informed the judges the same. The dispute was between myself and the judge president. It didn't involve any other judges there. It was up to that judge if that judge would perhaps want to choose sides, etc. I'm not aware who chose sides and who did what. I regarded it as a personal matter and as a matter between myself and the judge president. Therefore, if there's anyone who wants to allude...
Acting Judge President, I already gave a directive that we shall not discuss what may or may not have happened between you and former Judge President Klopi. Please, let's not go there.
Thank you, Chief Justice. Thank you, Chief Justice.
Thank you.
I would just like to make the point that it was just an issue between two people. Thank you, Chief Justice.
Thank you.
And then lastly, sorry, may I continue?
Yes, please, we're waiting for you.
Lastly, when you took over, what was the relationship between the office of the Judge President and the Cape Bar as far as acting appointments is concerned, and what was the relationship between that office and the bar in general?
Chief Justice,
Sorry, during which period?
Beg your pardon?
Just repeat the question, I didn't catch it.
I'm asking when Judge Goliath took over as the AJP, what the relationship between that office and the bar was.
Relationship between the court and the bar?
Yes.
Chief Justice, Commissioners, when I assumed office, I reached out to all the stakeholders. It was very clear to me that there was no communication between the office of the Judge President and many of the stakeholders that I had reached out to. The bar was but one of the stakeholders that I reached out to.
That is ground we traversed when I led you,
Yes.
Acting Judge President. You did tell us about what you've done, about stakeholder engagement
Yes.
and training and all of that. So
Yes.
For the sake of time, if anything, let's just...
Yes. Chief Justice, I had a meeting with the bar. I will leave it at that. I think I'm not going to comment on the nature of the relationship. Safe to say that I have re-established a relationship between the bar and bench.
And then just lastly on that score, there's a pro bono scheme in place with the bar. Would you like to explain to the Commission how that works?
Chief Justice, because of the problem with the criminal backlog and the fact that 80% of the judges were stuck in crime, and I only had 20% judges in the civil pool, the need arose to obtain outside assistance. And after I re-established ties with the bar, I approached the bar at our meeting, at our stakeholder engagement meeting. Proposals were put on the table for the bar to assist. Actually, it was an old project many years ago where the bar did assist on Fridays. I just expanded it. I reinvigorated the project after many years. And currently, there are about 30 advocates at the bar who make themselves available on a pro bono basis. I have re-established that project. The project is very, very productive, very fruitful, and it is increasing, as I have indicated, our productivity and our stats, more specifically with regard to in opposed motions.
And as I understand it, that system enjoys the sanction of the minister. And what happens is at the beginning of any particular term, a number of pro bono counsel are sworn in as judges for the term. And then when the need arises, if it's necessary at short notice, you can call upon them to come in and assist to alleviate the civil role.
That is correct, Chief Justice. That is the sole purpose of the pro bono pool. We engage with them and they would notify my office of their availability. Any date that they are available, they would notify my office and we would then make use of their services. And yes, their main role is to assist in the civil pool.
Thank you, Chief Justice.
Thank you, Judge Campbell. Mr. Boshoff, do you have questions?
Yes, thank you, Chief Justice. Morning, AJP.
Morning.
Chief Justice, I'm aware we are running quite behind schedules, but
Yeah, we still have 6 other people to
yeah,
interview
but with your
today
grace,
still.
if I'm used to having my 2 questions, but I'll try and make them quick.
All right.
AJP, so just firstly on leadership issues. You're applying for a position which is the key leadership role in this division. Now, a big part of management is people management. Now, you've at length addressed the complaints by Judge Ali, or the objections rather is a better phrasing. But what I find confusing is in your written response, you make mention of the reason why minutes were no longer kept. And the objection was that it might be seen as a stifling,
Yes.
etc. And therefore there was a resolution not to keep minutes. But you've now told this commission that in fact you do keep minutes, but your words were, they might not be visible to others. Now that to me creates the impression, because the purpose of minutes is to have a record which is then circulated afterwards and everybody agrees, yes, that is indeed what was said and that is what was decided. And as management, we move forward from that base. So what purpose does it then serve to keep these minutes on your own? And to me, at least, it creates the impression that it has the potential of weaponizing these minutes for a rainy day one day. And I'm concerned that that displays a misunderstanding of the nuance of why minutes are actually an empowering tool rather than a tool that could be used to create more mistrust, which is the last thing this division would require. And then just on that note, again in the line of people management, this complaint that you speak to your fellow judges through your registrar, and that the registrar is perceived as almost kind of being, conveyor of your instructions to your fellow judges. And please, I'm not detracting from your registrar's experience and importance. That's not the point. Just being in management myself, I think, and also having a superior, I would not take kindly if secretaries were carrying instructions to me or me to my team. It creates the impression of, well, I don't have time to talk to you, but So I would just like to hear your comment on that. That's my first kind of general question.
With regard to the minutes of the meetings, in 2010 a resolution was taken that no minutes should be taken at the meetings. I was the last scribe. I took the last minutes. And in case it didn't come out clear, what I indicated was that I make a record of issues that are discussed for purposes of an action plan. That is the reason why I make that notes as a leader. It's not meant for circulation. It is meant for action. If any proposal is made, if any recommendation is made, I must make a note of it to ensure that it is followed through. But Chief Justice and Commissioners, the resolution was taken in 2010 that judges want to engage freely and openly, and to use your words, no minutes can be weaponized against anyone. It was a resolution that was taken. I was the last scribe. I have institutional memory about that decision. The judges need to take a new resolution that we will in fact take minutes. But having said that, as a leader, you must note down action points. If something must be referred to the library committee, I will make a note. The judges who sit on the library committee will action it. If something must be followed up with the chief registrar, for example, where we resolved, I would make a note, we resolved that from now onwards, instead of 40 matters on the motion court roll, we are increasing it to 100. Those are the type of notes that I record so that I can know exactly what the issues were that was raised and what action was taken. And then there's a second chapter to this, Chief Justice and Commissioners. The meeting will reconvene, and we will do our report backs, and we will discuss if a matter was not properly resolved. So the fact that there's not formal minutes taken flows from a resolution that was taken 2010, because judges want to be free to air their views, and a statement that absolutely no minutes is taken by myself as the current acting leader in that division. It's not correct, because as the last scribe, I know the importance of recording certain decisions. So although I may not have returned as a full-time scribe where minutes are taken and circulated, or perhaps I should pause there, Chief Justice, since I have institutional memory. The minutes that I took in those meetings were just for recordal purposes. The minutes were never typed out while I was the scribe and while I recorded minutes. It was never typed and circulated. That didn't happen. It was only there for record purposes. If we need to go back and see what happened on a specific day, or whether something was raised by someone, we would consult it. But it wasn't typed, it wasn't approved, no one could change it. It was just for purposes of record keeping, and that stopped after a resolution was taken. So I'd like to reassure this commission and Commissioner Boshoff that the meeting and the salient issues are most certainly recorded in the meeting, and it is followed up. It's actioned, and it is followed up, and it is raised again if it hasn't been executed.
Thank you. AJP, then, look, I just want to preface the following question with two statements. The first is that nobody expects judges to be perfect. Everybody's human. So it's certainly not uncommon for judges to have their decisions taken on appeal and appeals upheld, etc. And then secondly, I want to just assure you I certainly don't take pleasure in the necessity of this question. But it's come to my attention there are two judgments of the SCA which have dealt with your judgments as court of first instance. The most recent one is Standard Bank v. Pygon Construction. And I suppose the first sentence of the SCA's judgment really sets the tone, in which Judge Gorvin wrote, "If the errors and their consequences were not so serious, this appeal could be said to arise from a comedy of errors." And in which the SCA then explained that there were liquidation and sequestration applications before you, and there was a counter-application to join as an intervening party and apply for business rescue. But then there was a settlement agreement which culminated in a consent order withdrawing the application to intervene and business rescue, and to place, and then issue provisional orders of liquidation and sequestration the discharge of which would be made contingent upon the sale of a property and payment of monies, etc. That then fell through, and the parties returned to court seeking, and this now Standard Bank, seeking final liquidation orders and sequestration orders. However, according to the SCA, you then ignored the consent order, didn't deal with it at all, granted the application for business rescue, and discharged the provisional orders. And the SCA in particular stated that you in essence dealt with a non-existent application, and given the consent order which you issued, had no jurisdiction to hear the issues of liquidation and sequestration any further. And the SCA, I just want to quote their words. Sorry, just in paragraph 28, I think I don't want to belabor the process with further quotations. But the court said, courts are not entitled to simply wish away previous orders or to ignore them totally when they bear on a matter at hand. In addition, where there is no application to set aside the order or the agreement, it is not acceptable to deal with either in the kind of offhand manner as was done in the judgment refusing leave to appeal, because you also subsequently refused leave to appeal. The entire approach taken to the matter by the High Court must regrettably be deprecated in the strongest possible terms. Then in an earlier 2014 matter, Pangaka v. Botha, the SCA also stated that, in which you then sat with an acting judge in a two-judge bench, that the failure of the High Court to appreciate or consider the appropriate principles, it resulted in a grave injustice to the magistrate that heard the matter initially, and it may well have irreparably harmed that magistrate's professional life. And the court again said the High Court's approach was to be deprecated. Now, as a leader, I would submit that, and especially when you yourself have now said that there is, given recent retirements, a bit of a shortage in the skills pool, a lot of new judges, and you're relying a lot on acting judges. Being a leader also requires mentorship and leading by example. And the question, I suppose, is how do you propose to do that when the SCA, in quite unusual terms, it's not, or let me rather say, it's not usual for the SCA when dismissing or upholding an appeal to speak in such terms of a court de quo's handling of a matter. What confidence does that instill in the public and those appearing in your division and those acting in your division and new judges who look to you for leadership on not only management front but technical abilities?
Thank you very much for that question. I just need to respond to the previous question regarding the role of my secretary. Honourable Commissioners, it is so that my secretary is interface with between my office and the judges, and it is so that my secretary would send out emails. Say, for example, it's the motion court roll. She would say to the judges, enclosed herewith, please find the motion court roll, and she would sign it off as my secretary. Obviously, all the judges know all the correspondence that emanates from my office, from my secretary, is sent on my instructions. If it's a document on which they must comment, my secretary would say, dear honourable judges, enclosed, please find a document for your attention. That is the nature of the correspondence between my secretary and the judges. I don't find anything concerning about that. My secretary does not issue instructions to a judge and says, please do this and don't do that. And it's all within a formal framework, is to convey information from our office, to send out a document for their attention, to inform them of the role or inform them of something that's happening next term, or it can be a memorial that's arranged. She notifies them that this is the time, this is the date, etc. So, Honourable Commissioners, there is no need for concern in terms of the manner in which my registrar communicates with the judges. Most of the communication is actually quite clinical and just informative, and to inform them of a situation as to when something's happening, or if there's a visit, a delegation that may come out, allocation of next term's motion court role. It's information that is being conveyed. No judge needs to respond to anything that my secretary forwards to them because it's clinical information. With regard to
just
yes,
a bit of clarity, does this secretary communicate directly with the judges or with the judges' secretaries so that they can inform their principals?
that's correct.
How does it work?
The email goes to the judges' secretaries.
Not to the judges?
No, some of the emails is for the judges and the secretaries are included. Say it's the motion court role, and then she will say, "Dear Honourable Judges, enclosed herewith, please find motion court role for next term." That is how it's done. Chief Justice, there's a reason for that because our computers intermittently goes off, and at least if we send it to both, we know someone is going to get it. But that is just a clinical role that's going out, Chief Justice. There are no instructions involved. It's just clinical information, or there's a memorial service, then it will go out to the registrars as well as the judges. That is the way it is done.
I must say, though, that I find that practice quite unusual. Well, speaking for myself, I've not encountered it in my 24 years on the bench, that a colleague communicates with me via the secretary. A secretary will communicate with the secretary, then my
Yes.
secretary will communicate with
Yes.
me. If the colleague is too busy,
Yes.
communicate with me herself or himself.
Yeah, Chief Justice, as the acting, as the DJP in the division, that is how it is done in our division. If it's clinical information, it goes to the registrar, only if it impacts on the registrar only. Remember, our system, computer systems are off intermittently, and it happened quite often where the judges are not aware of something that is happening. And it's some time ago that the decision was made to include the registrars also in those communications because the system is intermittently off. And the judges accepted that. It wasn't a problem. But it's all clinical information. So if there's a memorial service, the email would go to the registrars. The registrars must know because some of them attend a memorial service, and the judges would be told, this is the time you must be there, etc., etc. So that is the way it's been done. I didn't change any way of communicating the way the former judge president did it. I didn't do that, and we had lots of technical issues in the building, and it was later accepted that information must rather be disseminated two ways, that the judge and the registrar. Some issues only impact on secretaries. In those instances, the judges are not included unnecessarily. So what I did is I just followed through with the way things have always been done in the division. I didn't change anything, Chief Justice and Commissioners. With regard to the two cases mentioned, I have been interrogated about
Just before you carry on,
Yes,
there's a
sorry.
follow-up question on
yes,
the last aspect
sure.
from JP Mlambo.
Good morning, Acting Judge President
Good morning,
Goliath.
JP.
I just want to refer you, because this communication, judge to judge or judge secretary to judges, is a serious issue in the judiciary, as the CJ put it to you.
Yes.
One of the annexures to your PEC, sorry, I'm using case lines, it's page 41, 45, is an email from your secretary. Well, I take it as from your secretary. But it's signed AJP at the bottom, but it clearly comes from Elmarie Sivers. I don't know if you want to look at it. Because I
no,
want to know,
no.
because
Yes,
it's headed dear colleagues.
yes.
Now, a secretary can't say dear colleagues to judges. But this email is sent to judges. It's got AJP at the bottom. I need to
Yes.
get clarity.
Yes.
Who sent this email?
Chief Justice, if it says AJP, it means I stood next to her and I dictated it to her. It comes from me. And then at the bottom, it will show that she is my secretary. Perhaps with hindsight, I should have had my own stamp at the bottom. Yes.
I don't think it's a question of having your own stamp, because when I receive emails like this from a secretary, even if it's got the judge's name at the bottom, I will respond to the secretary to say, tell your judge to speak to me. Because this is an email from your secretary. My question is, why is it not an email from yourself?
JP, I understand the issue that you are raising. When I assumed my position as DJP, the former JP's registrar would also put her name in at the bottom. And I was trained that there's an understanding that any correspondence that comes from my registrar comes with my instructions. And that is something that the former JP always instilled in the judges. But the point is duly noted. It says, dear colleagues, it means that I have dictated it to her, and I typed my name at the bottom, and then at the bottom, the secretary's stamp would be there. So what I did, I changed that where my secretary, when my secretary types matters now, she would say that she's sending an email on behalf of my office. What I can say about the fact that my secretary sends out the email, that happened in the former JP's office also. His registrar would circulate an email, no matter what it was, whether it was the role.
We are not particularly concerned with what happened before your
Yes,
time,
yes.
AJP. So I would be
Yeah.
happier if you just limited yourself to
Yes.
what you've done in that
Yes.
division and plan to do for that
Yeah.
division, if there's anything
Yes.
to be done.
So if I can just conclude that point, when it says AJP, it means it comes from me. And then her stamp is just at the bottom as my registrar. Yes.
Minister?
Anything?
Oh, sorry, sorry,
Yes.
AJP, I should have warned you. There's another follow-up
Yes.
question.
I'm sorry, Judge Goliath, and good morning,
Good morning.
Commissioners. Good morning, how are you?
I'm very well, thank
Just
you.
a follow-up on that. In the Judge Ali's complaint, she also raises the matter of the secretary communicating directly with the judges. And she actually says she has raised the matter online in response to the PA, who had not indicated that she was acting on your instruction. It's actually paragraph 6.12. She says, I then took the matter with the email in response, and the secretary then resent the email with the words on the instruction of the AJP. I think the way the communication, and earlier on you said you are strong in communication. This indicates a weakness in communication with your colleagues. Would you agree with me if I say so? And futuristically, how do you hope to improve on the communication with your colleagues? I wouldn't want to assume that you are too busy to send a 3-line email to your colleagues and just informing them about the unopposed motion role for the following term. And then you attach it and it goes.
Yes. That is exactly, thank you,
Could I also
Commissioner.
just follow up, Chief Justice?
Yes.
Because it's also on this paragraph 6.12.
All right.
Yes, there's another problem, AJP, which is not just communication, because I understand your point to be, if it's formal communication, there's no problem. It can be sent by anyone attaching a role, etc. Now, I understand that fully. I don't have a problem with it. But it looks like it's more than formal communication. It's actually a substantive judicial work that is being conveyed through the secretary. I think that's really the concern. So the example that is made here at 6.11 is that your secretary has taken files to Judge Ali. And then Judge Ali says to her, no, I already have a file. And then she says to her, well, why don't you do this one virtually? And she does so without even discussing with you. So I think it goes beyond, this is just formal communication, into its substantive judicial instructions that are conveyed through the secretary. So the secretary's role is elevated, which is perceived to be offensive by your colleagues. That's really the heart of what you must respond to.
Thank you, Commissioner. Commissioners, that specific incident that is referred to, my registrar does not give the judges any instructions. My registrar, because we have a shortage of ushers, so my registrar doubles up as an usher. Remember, there are 33 judges and only 16 ushers in the building. And if the criminal trials run, then the ushers are occupied in the criminal courts, and then we don't have ushers to deliver files. Commissioners, that specific incident that is referred to was not any instruction given to any judge. It was just the delivery of a file. And when I saw that comment, I questioned my registrar about it, because my registrar is quite experienced and she's very, she understands protocol very well. She was nothing more than an usher on that specific day. And it happened to be on a Friday when that happened. Opposed motions, allocations were made the Friday for the Monday. And Judge Ali received the file from my registrar. My registrar never gives instructions to any judges. That was pure and simple ushering duties. My registrar has no interest whether a judge does a case virtually or in court. And my registrar personally had no knowledge of doing that, because she multitasks as my registrar, thank you, and as an usher. It was purely ushering duties. With regard to the signing of correspondence, I can understand that someone may have an issue, but if she signs it, it's formal, it's a roll that's being circulated, or it's the reserve judgment roll that gets circulated, the registrar signs that. Some correspondence would be from me, whether I circulate the information for comment, that can also come from me, or it will say AJP with her name as my secretary at the bottom, but it will clearly say it comes from me. Formal correspondence can come directly from my secretary, but I'd like to reassure the Commission that I do put AJP under correspondence that I have dictated personally to the judges, quite often. So if I can just clarify the point with regard to my registrar telling a judge do it virtually. Commissioners, that is not the case. My registrar would not even open that file to see the mode of the trial. It was a simple case where a file was allocated with the name of the judge on, and she was just performing ushering duties, nothing more, nothing less, and she still performs ushering duties if the ushers are not available to go and deliver files. So I think that act of hers is taken out of context because she does not know the modalities, and she cannot dictate to any judge how to conduct a hearing. And hence, I do dispute that allegation that my registrar attempted to tell someone how to hear a matter. That is not the case. It was a simple delivery of a file.
Yes, but she says that she never got any communication from you, which left her uncertain about whether, in fact, this had come from you or it had come from your secretary.
Commissioner, the judge won't receive communication from me with allocations. They get the file 2 days before the time. Their names are put on the file, and it gets entered into the register. So I don't communicate with the judge and say, I'm sending this matter to you today, I'm sending that matter to you tomorrow. Our system works like this. We allocate in advance, depending on availability. The ushers collect the files that's been allocated with the names of the judges on, and they manage, the ushers will deliver the files. You don't email every judge every day to say, here's this matter, there's this matter. That is not how the system works. So they can receive a file today for a matter to be heard 2 weeks from now, and if there's not an usher to deliver it, my secretary will go and deliver the file on behalf of my office.
Oh, sorry.
Is there anything else?
Commissioner Baloy? Still follow-up questions, HAP?
Yes. Thank you, Chief Justice. Good morning, Judge.
Good morning.
It's a slightly different angle, but to this topic still. The Chief Justice asked you more than once what it is that you would still do in the division by way of improvements and new things, and you were asked more than once. And in your responses, you were referring to what you have done. Now, I would have thought that a letter, this submission from Judge Ali, for example, would give you an opportunity to reflect on what you would need to do if you are appointed Judge President, because clearly, according to her, there are issues that need to be resolved. But instead of you saying or acknowledging this, you have taken a stance that what she's saying, there's no merit to what she's saying, and your attitude is that's the end of the matter. I'm quite disappointed, I must say, by the tone and the manner of your response to this, but perhaps more seriously, by your registrar's response, where she speaks about a judge to say her statements are deplorable, that kind of language, and that you would include this without moderating it. You would include it to be put before this panel about a judge that you're going to go back to, work with, and if you're appointed to the position, lead and hopefully, at least as far as we hope, have a collegial relationship with her, that you would allow, firstly, without moderating, that your registrar would speak in these terms. I'm particularly concerned about that. Because I perceive of a role of a judge president as being the moderator among equals and among staff. And so expected that you would tell her to tone down her language, address the complaints or the issues that are being raised without speaking in this way. To me, it appears to be as absolute disrespect, and you don't seem to have noted it, that your registrar should never speak like that to any judge whatsoever, in fact, not even to her colleagues. But I'm also particularly disappointed that when you respond to Judge Ali, you come out as more defensive than acknowledging this is an indicator of issues that require addressing. The minute issue. It doesn't help to keep saying, we stopped taking minutes 10 years ago. Clearly, there's a judge now who thinks we should keep minutes. And I would expect a leader to say that clearly means there's an issue to be addressed, and I would go back and address it. Do you have any comments to that? It is concerns that I have, and they seem to me to speak perhaps to a failing of leadership.
Commissioner, I did respond to Judge Ali's concerns. It is so that she has raised issues, and I have responded to it. And if I can refer to the issues regarding minutes, I am keeping a record of what happens at the meetings. I must agree that perhaps the tone of my secretary's response could have been better. My secretary just felt aggrieved that a specific judge said that she mustn't deal directly with her, but I will concede that the tone should have been better. The issues raised by Judge Ali, I indicated to the Commission that I'm happy to respond to all of it. With regard to my registrar responding to judges, obviously that is a lesson to be learned, to the extent that my name should then rather just be typed. She mustn't just put AJP at the bottom and then her name underneath as my secretary. Her stamp, it's actually a stamp. which would possibly preferably have been my stamp. Some of the concerns raised by Judge Ali, Commissioner, I have responded to it. I don't necessarily regard it as being defensive. I will concede, I've given an explanation as to how my office functions. With regard to minutes, that is something that can be raised at a judge's meeting. Quite frankly, Judge Ali could have raised it with me earlier. All the issues she has raised there could have been raised with me earlier.
Yes, I accept,
Yes.
AJP, I accept that she could have raised the issues earlier, but they have been raised in this way.
Yes.
And what I'm putting to you is your response in the manner in which she has raised them seems to indicate a failing in a leader responding to matters raised in the wrong way, maybe. But that the instinct of a leader should be, it seems to me, to accept that indicates there's a problem that does need to be dealt with differently. But I do understand your answer. Thank you.
Yes, thank you,
Thank you,
Commissioner.
Chief Justice.
I feel that most of the issues raised could have been dealt with directly. I have responded to the issue of minutes that I do record. I've responded to the distinction between expedited dates and semi-urgent dates. I have responded to the fact that my secretary communicates on clinical issues with the judges, and sometimes the emails would go directly to the registrars, depending on what it is. Commissioners, with regard to issues raised by Ali, I did not, my intention was to respond to the issue, not necessarily to defend myself, because if there's a difference between an expedited date and a semi-urgent and an urgent date, I felt that I needed to clarify. So in that respect, I considered my response to be more clarification, because Judge Ali is not aware of all the processes that happens in my office. I have noted the comments, and obviously I have spoken to my secretary about that in terms of remedying a concern raised by one judge in the division in terms of the manner the communication gets circulated. And I just followed up on the way it has always been done through the registrar. We send clinical emails, but yes, I am alive to the fact that some judges may then take offense, and Judge Ali then expressed that she took offense to that. Is there anything else I just needed to respond
No,
to?
wait. There's
Yes.
still more follow-up questions, AGP. Commissioner Pillay?
Thank you, Chief.
No, there are two follow-up questions before you, Commissioner Malema. I've noted you.
Thank you, Chief Justice. Good morning, AJP Goliath. I just wanted to follow up on the answer to the question posed by Commissioner Ngcukaitobi around the specific incident referred to by Judge Ali in her document, the one relating to the allocation of files and
Yes.
the comment made by your
Yes.
by your secretary. Did I understand your answer to be that that's an untruth by Judge Ali?
I have raised it with my secretary, but the secretary indicated to me that she was merely delivering the file because, look, that was the instruction. She acts as an usher. And the secretary indicated that she did not instruct the judge how to hear the matter. Commissioner, the secretaries cannot dictate to a judge how to hear a matter. So obviously my secretary indicated that that was not what she had said. The file was marked and she acted as an usher, and it happens on a daily basis that my secretary delivers files to judges.
AJP, the thrust of my question is what you're saying to the commission, that Judge Ali, in her comment to the commission, included a fabrication or an untruth.
I'm saying to the commissioner that I addressed that issue with my registrar, and she indicated to me that she did not indicate to the judge how to hear a matter. She was merely performing duties of an usher.
And did you have a similar discussion with Judge Ali?
No, I did not have that discussion with Judge Ali. I just instructed my registrar and indicated to her that it may be best that we rather just wait for an usher to deliver it, because it was taken, this incident had happened. Commissioners, my secretary is there for many years and she knows protocols.
Judge,
She will not instruct a judge.
AJP, I'm
Yes.
sorry to interrupt you. I really don't want to have a discussion about
Yes.
your secretary. I'm more concerned about what you're saying about one of the judges in your division. That's my concern. And can I just finish my question before you answer? You see, it ties into what something you said much earlier in your exchange with the CJ. You urged us, in your words, to treat Judge Ali's comments with caution. Now, that's a very serious thing to ask the JSC to do, in particular when you're talking about a sitting judge. Now, you also, in your written responses, tie that in to Judge Ali's membership of NADAL, which is even more concerning. Now, can I ask you to please address that question? Firstly, how it is that you can ask this body to treat the comments by a sitting judge with caution? And secondly, how it is that you tie that into her membership of NADAL?
Commissioners, I have given an indication that Judge Ali and I, we were together, we were candidates for the position of Deputy Judge President. And since my appointment, it is so that Judge Ali did not communicate with me at all. It is so that at that stage, NADAL did mobilize support for Judge Ali, and she wasn't appointed. So from that vantage point, although Judge Ali stated in her submissions that she is raising this because she's got nothing to lose and she's due to retire, etc., I had a concern about the fact that it appeared as if the fact that we were up against one another, that it may have impacted negatively on our relationship, and that Judge Ali, she raised certain issues, concerns that I felt I could explain adequately to the JSC in terms of the manner in which I run the office. But my main concern was, why did Judge Ali not address it directly with me? That was my concern, because Judge Ali chose to use this platform, and that was where the caution request came in, because it was something she could have raised easily with me, to take a walk up to my office, and we could have resolved any of her concerns. And that it's in that context that I asked the Commission to just be cautious, because why didn't someone do the obvious? But I understand the concern raised with regard to the fact that I now need to decide, am I believing what my registrar says and Judge Ali says? Obviously, if I can just conclude the earlier point, I must believe what the judge says. If a judge says something happened, I must believe the judge. And I did raise it with my registrar, and my registrar said, but Judge, I was just performing ushering duties.
You mentioned that, AJP.
Yes.
And can you please address the insinuation that NADAL is using Judge Ali as an instrument against you?
Commissioners, look, NADAL issued a media statement in May where they requested individuals and organizations to collaborate with them to support a candidate. And that happened. That is the reality of the matter. Judge Ali is affiliated to NADAL. They nominated her at the time. NADAL did seek collaboration from stakeholders and from individuals. It was a public document, and I didn't, for me it was unambiguous to the extent that NADAL was seeking collaboration. And Judge Ali was a long-standing member of NADAL, and NADAL did nominate her for the position of DJP in that round when I was successful. I'm not saying that NADAL is using Judge Ali for a specific purpose. I'm saying Nadal publicly did invite people to support their cause and to collaborate with them. And just the mere fact of Judge Ali's connection with Nadal, it's not an arm's length person who had no ties with Nadal at all. After all, they did nominate her. For me, it's just a factual situation. The invitation went out, and that is the ultimate strategy that Nadal called for, and people did, and they invited people to come in. Judge Ali has never been to my chamber since I was appointed as the DJP, so I would imagine that there could be a little bit of, there could be issues that she may have. Since my appointment in 2016, she's never been to my chambers.
AJP, please.
Sorry, Commissioner Pillay, in case I forget, I'm at that age. Just on this last point, have you ever been to Judge Ali's chambers?
Yes.
As her leader?
Yes, I have been to Judge Ali's chambers.
All right.
Yes.
That pacifies me.
Sorry,
Carry
just
on,
a last follow-up, AJP, on the question of Nadal. Do you believe, AJP, that every person who is a member of Nadal will be biased against you?
No, definitely not. The position with Judge Ali is just, the connection is just that they nominated her as deputy and I was in the successful candidate. That's the only connection I can make. I cannot have a blanket approach and say everyone. I was also a member of Nadal. So I most certainly cannot have a blanket approach and adopt that situation. Judge Ali's position is just unique in that we were up together for the position of DJP. She has raised certain issues that she could have raised with me directly, some valid, some not so valid. I have responded to it. I've noted the commissioner's stance that says that as a leader, I must say, how am I going to fix it? Yes, I am quite willing to fix whatever needs to be fixed, but my responses that I gave was an explanation as to how my office functions. And that is why I said if the commissioners ask me on a specific aspect raised by Judge Ali, I am happy to respond there too. So the situation with Judge Ali is just different because we were up against each other for deputy. And that makes, for me, that makes her situation unique. That is all. Nothing more than that. And I most certainly cannot have a blanket approach to all members of Nadal. Definitely not.
Sorry, Chief Justice, sorry, I know we haven't even gotten to a response to my second question, but I really need to address this because, AJP, you're not taking this commission into your confidence.
Yeah.
The issue with Nadal is not relating to what happened when you applied both for the DJP.
No.
In fact, you've asked that one of the other commissioners recuse himself because of
Yes.
his membership or his affiliation with
I
Nadal
did.
because a competitor
Yeah.
to this role
Yeah.
is, I suppose, affiliated with Nadal or is their chosen or supported candidate.
Yes. Yes.
It's not about what happened in the past and
Yes.
Judge Ali has an axe to grind because she was unsuccessful. The insinuation is that you are using her, or they used her, to ensure that their preferred candidate in this process gets the nod and you don't. Which is essentially accusing Judge Ali of being part of a conspiracy, along with fellow commissioners. That is a very serious accusation, and it's not to do with grudges in the past. You are accusing people of essentially something that verges on criminality.
CJ, may I please
Yes.
follow up on that with your permission?
Yes, Commissioner Goliath.
Yes. While you deal with that, AJP Goliath, could you please also deal, and in similar vein, we've had an issue where you've expressed concern about the ability to remain unbiased and neutral of a senior judge of your court that was supposed to sit here who participated in the shortlisting, and you demanded, rather in fact you instructed that he recuse himself, you recused him, and you appointed somebody else to come and stand in your place as your designate. Now, the reason you gave for that is exactly the same as the basis on which you were seeking Commissioner, the one Commissioner's recusal. It is because of their familiarity to your competitor, and so you do not trust that the judge will fairly, openly, and objectively exercise their duties and discharge their responsibility in evaluating you fairly. So could you please, while you respond to the Nadel issue, deal with that as well?
Commissioner, Judge Ali mentioned in her submissions that she has no agendas. She mentioned that herself. And when I saw that, I thought, well, why is Judge Ali saying this? It's not necessary to say this if you don't have an agenda. And the connection with Judge Ali, the fact is that Nadal, she is a member of Nadal, and they did nominate her previously. I am not saying that
She was.
Judge Ali,
She can't be a member of
yeah,
Nadal
she was.
whilst the judge, yeah.
Yeah, she was, just like I was. I was also a
Me
member
too,
of Nadal.
and many of us.
Yes, many of
on
us.
the bench.
Judge Ali triggered this concern by me because she said herself, I don't have ulterior motives. I've got nothing to lose. That's what she said herself. And I looked at it and I thought, but why is she saying this if it's all above board? She triggered that concern by me. And the Nadal sent a circular around and made it clear that they support a certain candidate. There's no problem with that. The only problem I had with the circular was the fact that it created the impression that the Western Cape Division was in disarray. And I felt that that was not the correct statement to make. If that was not in the statement, I would not have had any concerns. The fact, because that is not the correct statement. It was not about supporting another candidate, whatever. The division is not in disarray, and I can assure the commissioners of that. I just need to respond to if anyone...
No, I need to make a follow-up,
Yes,
CJ.
yeah, sure.
There still is another follow-up before you, Commissioner Malema, on this very issue from President Mulemela. Or had you finished, Commissioner Pillay, because we kept interjecting?
Chief Justice, there's just so much to deal with. I'll keep
All
my-
right, thank you.
my question.
And you satisfied, Mr. Poshoff?
Yes, thank you, Chief
All right.
Justice.
President Mulemela?
I wanted to remind CJ that we spent 2 hours on this candidate. 2 hours.
I am fully aware, Commissioner William. Thank you.
Thank you very much, CJ. My follow-up. Am I audible?
Yes, we can hear you.
Okay, thank you. Yes, good morning.
Good morning,
My
Commissioner.
sister, how are you?
I'm very well, thank you.
Just to put on record that you and I have interacted frequently in relation to me requesting you to release some of your colleagues for purposes of acting at the SCA, and that has worked well.
Thank you.
Yes. My follow-up pertains to the issue of the taking of minutes. You indicated that you were a scribe in 2010, and then there was a resolution that minutes should no longer be taken. And then you took over as the AJP, and then you started making notes or recording notes for purposes of an action plan. My question to you is, well, the CJ also asked you whether there's any room for improvement that you see. And my question is whether you do not regard the issues that have been raised by Judge Ali as an indication of the need to keep proper records in accordance with standard meeting procedures and to circulate these records, especially because you indicated that not all the judges can attend meetings at all the time, meaning that if these minutes are circulated, then even the judges that did not attend the meetings would then be kept abreast of the discussions of that meeting. I pose this in relation to one of your responses to the CJ, where you said that it is evident that Judge Ali is not aware of some of the processes that you have put in place. And I mean, discussions that are are had at judges' meetings, if they are recorded, even if she did not attend a particular meeting, she would know that this was discussed and this is how it is being attended to. So with the benefit of hindsight, would you concede then that the area in relation to the keeping of minutes is one area in which there could be an improvement on your side going forward? Thank you.
Thank you very much for that question. Most certainly, I agree that we can do better in that regard. Commissioners, my first meeting that I held with the judges, where I asked the judges to have the conversation, I did minute that meeting because I wanted to record exactly what it's our first meeting after 6 years, and I did circulate the minutes, and the minutes ended up outside of the building and with the secretaries. And the court manager came to me and said certain things were said about her in the minutes. Minutes were circulated, and then a senior judge came to me and reminded me that there is a resolution that no minutes will be taken. So from the second meeting onwards, I only made notes in respect of an action plan. So, Commissioners, I agree with what President Malamela has indicated. We can most certainly improve on that, and it is something that will have to be discussed at the judges' meeting so that we can take a definite resolution as to how we will be going forward since there is a resolution still in place not to keep minutes. And the fact that I'm keeping an action log and actioning things and dealing with the different committees, etc., may not be enough. It would probably be advisable to have some other system in place with the concurrence of the judges, since that resolution still stands.
Thank you, AJP. But before you get to the second part of Mr. Boshov's
Yes.
question concerning the SCA's comments
Yes.
on your judgment, I just want to remind Commissioner Malema and the other commissioners that this is a critical leadership position in a notoriously troubled division of the High Court in this country. So I cannot stop commissioners from asking questions about concerns relating to serious matters that they may have. So if we have to take longer with a candidate, then that's just what we must do, so that at the end of the day, we know that we have chosen the right person to lead that court. So that's why we're taking so long, Commissioner Malema. Back to you, AJP. Are you
Yes.
ready to?
No, my follow-up.
Yes.
Oh, you had a follow-up?
Yes.
I thought you just wanted to remind
No,
me
no,
about
no,
the
no.
time.
This is why.
Ask your follow-up then, Commissioner Malema.
No, I want to just make a follow-up on 2 points quickly, AJP. The Advocate Baloyi, Commissioner Baloyi, raised an issue with you about how your secretary responded to a judge. And you said, that is not the right way to communicate, but she was angry or
Yeah.
upset that they accused her of whatever they did. Before Commissioner Baloyi put that to you, as a leader of the court who read what she said in response to Judge Ali, did you take it upon yourself to say, but you cannot address a judge like this to your secretary? Did you say that to her?
I did not say that to her, and I think I should probably have done better in that regard. But she indicated that she wanted to make her own statement. But I think I should have done better to intervene there.
And you see that is lack of judgment from a leader, because a good leader would have picked that up and immediately deal with it. Do you accept that that is lack of judgment from leadership position?
I should definitely have asked her to tone down her response, Commissioner. Yes.
So, AJP, you are not in the meeting where it is alleged she was instructing a judge to conduct the matter in a particular way. And Judge Ali makes that allegation, and she denies that. and then you come to justify before us that she's senior, she will not have made such a mistake, she knows how the things work, and that we should, without you saying it, but by how you saying it, we should believe her over your colleague, over a judge, and you have not spoken to that judge. You have just spoken to one person, who's your secretary, did not speak to the judge to verify the facts and whatever the situation might be. But your justification here is that, no, she's so senior, so experienced, she will not make such a mistake. She will never give a judge an instruction when a judge says, I was given an instruction. And we must believe her over a judge of your court, AJP.
Commissioner, the fact of the matter is that it is a problem for me to say, don't believe the judge. I'm not saying that here today. I am saying that my registrar is used to delivering files and playing the role of an usher. Since I'm a DGP since 2016 already. And she is alive to the fact that it is just a delivery. And if that had happened, it is unfortunate, and I cannot say today, believe my registrar, Commissioner, I can't say that. I must accept what the judge says. I just try to impress upon the Commission that the delivery of files is within the normal course of my registrar's duty. And that's the sole purpose, is just delivery of a file, not to engage judges on the matter. And quite frankly, it gets placed in a basket. Let me just clarify that to the commissioners. It doesn't, you don't knock on the door of the chambers, it gets placed in a tray by the judges' chambers. Yeah, that is how deliveries are made. The usher will do that, place it in the in tray, and then there's the out tray. The usher will collect the files. So the delivery of the file, she wasn't sent as a messenger to the judge concerned. She was merely sent to place it in the tray, in the in tray. That is all.
Sorry, Chief Justice.
Yes.
Sorry, can I?
All right.
There are other, we still have other follow-up questions.
Just
Sorry,
my question.
questions, Mr. Notjes. Commissioner Mwimang?
Thank you.
Thank you, Commissioner Williams.
Thank you, CJ. Good morning, AJP.
Good morning.
Just want to make a follow-up on the correlation that was drawn by Commissioner Baloyi on the designation of alternative on Judge Erasmus.
Yes.
And Judge Ali. On the question that was raised by the CJ around what is it that could be done to improve the stability on the division, the question that I want to ask is, don't you think that your approach on Judge Ali and also on Judge Erasmus is devoid on the quest to create stability in the division, because definitely the insinuation that one is throwing is that your stance on throwing Judge Erasmus midway through the process also creates a bit of a leadership discord on how you manage the issues of court. Don't you think you should have handled the matter differently? Because now you can imagine the relationship between Judge Campbell and Judge Erasmus, I suspect, is something that you need to work on to stabilize it. Thank you.
If I can just conclude with regard to the issue of Judge Ali. I'm sitting here with a list of the stuff that she has raised now. She referred to the allocation of duty for unopposed motion role. She had a concern that when judges are involved in criminal matters, they shouldn't be taken out of crime because there's a continuous role. I have responded to that to explain to the Commission that the continuous role will be disrupted because of criminal matters, where we have 80% of the judges in crime. The allocation of the duty of the unopposed motion role is done in an equitable manner because it involves weekend duty, and it so happens that some judges were allocated to this allocation of duty in the unopposed motion role 2-3 times per term, which translates into working 2-3 weekends per term. So I have responded to that to explain that I adopted an equitable system of allocating the unopposed duty role to all judges. If they are in crime, they sit out for 4 days out of their crime during that week that they are allocated the unopposed motion role. It's an equitable system, it's a transparent system, and the majority of the judges were happy with the way I did the allocation of duty for the unopposed role. Judge Ali raised the issue of expedited dates. I have explained to the Commission that there's no list of criteria for the allocation of expedited dates. I've been doing that since I was the DJP, and that Judge Ali is confusing expedited dates with urgent and semi-urgent matters. Expedited dates are granted in a transparent manner. Both legal, all the legal representatives must apply together for an expedited date. Based on the merits of the case, it will be approved. From there, it goes to the 4th Division clerk, who will then find an earlier slot for the parties in that matter. So I have responded to that. Designation of judges as junior and senior, it is so. When we allocate full bench appeals, we try to allocate one senior judge in the higher hierarchy and then a mid-judge with middle, less experience, and then we also put what we would call a junior judge, a 3-bench judge, so that the junior judge can then gain that experience by getting exposure to different judges. So that is basically the only reference where one would talk about junior and senior. But in any event, I have responded here, and I said that allocations are done privately, and there's no discussion around junior or senior when allocations are made. Judge Ali raised the question of questionable statistics and performance tools. The stats is completely out of my hands. I have no interest in the stats. It is done by the statistician using objective criteria when the stats are computed. Failure to circulate timeously, I've responded. I've indicated that the resolutions were indeed circulated. The phase 1 was not under my leadership. The rationalization report was circulated, and the meeting that Judge Ali referred to in her papers was in fact a meeting where I went to convey to them, the judges, what issues that were raised in heads of court. Concerns that my secretary is allowed to communicate directly with judges.
No,
I have noted that. I've noted the concerns raised with that. It is so that my secretary does send out correspondence and communicates with the judges and the registrars. I have duly noted that point that was taken. No records of decision taken at meeting. I have noted that point as well, and I think based on the question of President Molamela, there is definitely room to improve. The judges need to make that decision because I've explained when I circulated the minutes of the first meeting, it was a problem and I was reminded of this resolution. So that is something that the judges will have to work with. With regard to my registrar's response, I concede that I should have intervened and perhaps she should have toned down her response. Before I get to, I don't know, Chief Justice, I'm in your hands. Do you need me to respond?
There was the issue raised by Commissioner Baloyi and fortified by
Yes.
Mr. Boshoff about your withdrawal of your
Yes.
colleague's designation,
Yes.
Judge Erasmus,
Yes.
and then
Yes.
your demand for one of the commissioners to recuse themselves
Yes.
because they
Yes.
are a member of
Yes.
NADEL.
Yes. It is correct that I did demand one of the commissioners who holds an office in Adel to recuse himself. It is so that the test for recusal is objective and whether a reasonable objective and informed person would, on all the facts, reasonably apprehend that someone will not be able to bring an impartial mind in the matter and in the assessment of candidates, or that that person wouldn't be open to persuasion. It was purely done on that basis, to ask the president of NADAL to recuse himself. Nothing more, nothing less. I tried to, although I'm subjective, I try to put myself in the shoes of an objective person, and I felt a sense of anxiety, and it was my view that even looking from the outside in, if the president of NADAL sits here having circulated the memorandum, it creates the impression that his mind was made up and that he would not be open to persuasion. It was purely on that basis that I made that request. Had that memorandum not been, the media statement not been made, I would not have asked for his recusal. But the main reason for the recusal is not the support of a different candidate. The main reason for the recusal is the fact that an incorrect statement was made in the media statement that the division is in disarray, and the division is not in disarray. The waters are calm, the ship is sailing. It's not perfect, but it's much, much better from where it has been. So that recusal must be viewed in that light. It was a public document, it was circulated, and I attempted to apply that objective test, and I did say to myself, but if someone already belongs to this organization and it's already indicated this is the preferred candidate, I felt that perhaps it would be best if that person is not party to, sits on the commission, because I had concerns whether that person would be able to apply his mind going forward, to apply, would be open to persuasion, because a decision was made before any interviews or anything. Would that cover that?
Your withdrawal of Judge Erasmus's designation to this body?
Yes. The commissioners, the shortlisting process occurred in this manner. I was instructed by the Chief Justice to let Judge Erasmus attend to the shortlisting.
Which Chief Justice?
Chief Justice Zondo, former Chief Justice Zondo, indicated that Judge Erasmus must do the shortlisting. We are in a unique situation because I'm also a candidate. So the former Chief Justice then recommended that Judge Erasmus must attend to the shortlisting, and I abided by that decision.
Follow up, CJ, on this point. Because I think
let her finish. She's still talking.
Yes, yes. I received a call from the JSC instructing me to let Judge Erasmus attend to the shortlisting commissioners. I received that phone call. And then Judge Erasmus attended to the shortlisting. I abided. And if I can go further, then the shortlisting did take place. And then, when I saw the shortlist, I just saw someone's name on the list that has a very close relationship with Judge Erasmus. And at that stage, I didn't make any designation yet when the shortlist came out. So that was my concern, where he was concerned. It's just the fact that he's got a friend, it's a friend of his. And that was my only concern with Judge Erasmus. I thought he may be conflicted with one of his friends being shortlisted. Nothing more, nothing less. So firstly, I didn't designate him to do the shortlisting. That was on the instruction of former Chief Justice Zondo. After the shortlisting, I had a conversation with Judge Erasmus. I said to him, look, your friend is on this list. I have concerns about that. So I will not be able to designate you to attend to the JSC today. He did try to persuade me to say, no, he will be able to apply an impartial mind, but I thought, I have a concern because I know personally that that is his friend on the list. And then I did my designation on the 8th of August. I designated Judge Gamble after considering my options. I designated Judge Gamble, and that was the only designation I made. The Chief Justice designated Judge Erasmus. I did consider designating Judge Erasmus, but when the shortlist came out, I then designated Judge Gamble instead. So from where I sit, I didn't change any designation at all. I just applied my mind in terms of Section 178K after the shortlisting to designate a judge. And my motivation was to designate a judge that has no close ties with any of the candidates. None of us are friends with this particular judge, and we don't have lunch, we don't have breakfast, nothing with this particular judge. I'm not particularly close to the judge. The judge that I designated is due to retire on the 10th of November, and that judge holds no allegiance to any one of the candidates at all. So if I can then just...
No,
Chief Justice.
before you move on,
Yes.
AGP, I just want to understand why Judge Erasmus's close connection with any of the candidates would have bothered you, because you've been a judge long enough. We all know that since the beginning of time, since this body started operating, commissioners, including the chairperson on occasion, have declared openly that they have a relationship with one of the candidates, and it's never been an issue. I recall an example where former Chief Justice Mogoeng interviewed his close friend, former Chief Justice Zondo, and he made that declaration openly before the interview started, and it was not an issue, and a fair result was achieved.
Yes.
I'd like to think. So why were you particularly bothered by Judge Erasmus's involvement in these proceedings?
Yeah, Chief Justice, look, I'm 34 years in the profession, and yes, I was concerned about that. It may not be, based on what you have informed me now, it may not have been the correct approach not to designate him, but at that stage, after the shortlisting, I had a choice as to who I would like to designate. And the Chief Justice Zondo designated him to do the shortlisting. And I exercised my discretion in terms of who I wanted to designate to represent the division. Yes, it was a concern, and I've heard what the Chief Justice had said. I just felt uncomfortable with the fact that one of the candidates was very close to him, and I've noted what the Chief Justice said. But the Commission must remember that and I'm trying to understand this, is the suggestion that because the Chief Justice designated one judge that I had to stick to that judge? Because if that is the case, then I understand what the concern is about, but I thought I was just exercising my constitutional right to take someone who's not connected to anyone and who's due to retire and who can sit here objectively and represent the division.
Quick
No,
one,
what
CJ.
was odd, Commissioner Balema, there are other follow-up questions before.
I wanted to follow what you just asked earlier.
Okay.
I wanted to ask, are you aware of the incident that the CJ is talking about? As a judge, you have been on the bench for quite some time. You will be familiar with what she spoke about. And when you had those concerns would have now been put at ease by that experience,
Yes.
which we are speaking about. AJP, you are not going to give us the second reason because you build reason as you go. Your initial and your honest reason is that Erasmus is a friend with a candidate. Not that I was exercising my rights.
Yes.
The rights is something that you are now trying to put here now, after giving us an unacceptable explanation. So, do you realize that you were wrong to remove him on the basis of the friendship with another candidate? Because that has never affected this body, and this body is not Erasmus Commission. It's the Judicial Service Commission. There's no Erasmus who's going to take a decision here alone. So whether he's got a preferred candidate or not, this body must still take a final decision as to who's going to be. Do you accept you were wrong by taking such a decision on a fellow judge and say on the basis of a friendship, this judge will never be objective and will not judge me or score me fairly? Do you think you were right by removing a fellow judge on the basis that he's a friend with a candidate? Do you accept you're wrong?
I accept that, having listened to what the Chief Justice says, that you can interview a friend, an example made. The fact of the matter is that I have never designated Judge Erasmus in the first place. The Chief Justice designated him. And I was of the view that I could exercise my right to designate an alternate. And I'm hearing what the Honourable Commissioner has said. What the Honourable Commissioner is saying, that I should have retained the person who had done the shortlisting. I should have retained that person there. My concern was, am I entitled to appoint a designate or not? Because I was not involved in designating anyone for shortlisting. And I suppose it is desirable to keep the person in, but is it wrong for me to exercise my right to designate an alternate that has no connection with any of the candidates? I thought that I was designating someone that I was satisfied is not connected. I've heard the sentiments that the fact that Erasmus was closely connected to one of the candidates did not justify me not designating him. I heard that statement, and at the time I just felt that I didn't want him to feel compromised by sitting in on proceedings where one of his close friends were.
Commissioner, Professor...
As for a follow-up, Chief Justice, I'm terribly sorry.
Commissioner Murumakaye...
No, but it's just a corrective fact, and I think it's a real problem.
Yes.
So I'm sorry, Professor, you know that I don't...
He's the convener of the Objections Committee, and they've been dealing with this, so he gets first dibs because of that.
Yes, thank you. I've also tried to apologize to the Professor. So the problem, AJP, is that you've now, I think, 4 times said you never made the decision to assign Judge Erasmus to attend to the shortlist. That was done by the Chief Justice.
The Chief Justice instructed me to designate him, yes. Former Chief Justice.
That's now a different spin on it. But the problem is that on the 8th of July, 2024, you wrote to the Secretariat, and your email says, our telephonic conversation refers, please be advised that Judge Erasmus will be attending to the screening and shortlisting of the candidates nominated for the position of Judge President of the Western Cape Division of the High Court. I will be attending to the screening and shortlisting of the 4 vacancies in the division. Kindly confirm the time scheduled for the shortlisting of the 4 vacancies in the Western Cape Division. So whatever was happening in the background, it was your decision to send Judge Erasmus.
Yes, I did send Judge Erasmus. I complied with the directive of the former Chief Justice. I did. And since I was a candidate, that was more reason why I complied. Yes, I did.
Yes, sorry, Chief Justice, it was just to correct the fact that Judge Zondo had nothing to do with it. It was the candidate.
Thank you, Commissioner.
Yes, I accept that I have sent that letter through, and that letter confirmed the designation of Judge Erasmus to attend to the shortlisting. I did.
Commissioner Notice, your hand was up hours ago.
Yeah, not just, I mean, on this point, you know, I'm saying that with great respect to you, and I highly hold you in high esteem as a judge. By removing Judge Erasmus and seeking for commissioners to recuse themselves, all what you're doing, you were designing your own interview panel. That is it.
I accept
nothing else. All what, I mean, I must put it this simple so that we understand, so that everyone do understand what we're doing. Yeah, the first thing the first thing you do, you want commissioners to recuse themselves for flimsy reasons. And you, in the process, you even, I mean, for instance, I hear you say, I circulated a statement. There's simply no such a thing, and you can't say. Two, you designate, I mean, judges to interview you. That's why you interfere in a process where you are directly involved, and you don't just interfere, you actively involve yourself. The whole point is that you just wanted, you have to have your own interview panel. And that was wrong of you, as one of the lack of your judgment as a judge.
Commissioner, the Nadal issue, I have raised that already, and I have accepted the decision that you remain on the panel. I have explained that because of the media statement dated in May, that I felt a sense of uneasiness about it. And you are sitting here now. I have accepted that decision. With regard to the Erasmus issue, I could designate someone. So the main criticism is that because Judge Erasmus...
Sorry, Judge,
yes.
I know you,
yes.
I mean, I don't want to
yes.
you. The point I just expel out, or what I'm putting to you is simply that by involving you in this process, designating, removing persons that you have designated, all what you are doing is to appoint your own interview panel. Was that right for you? Should we have even in the first place been involved in this process, especially after we have designated a person? Must you come again and say, oh no, I don't like you, I want somebody else. And even Judge Gamble, in terms of your own, what we call, a hierarchy of judges, she's not even the second, third, or fourth in the row. She is somewhere in the 11th in terms of your own seniority in that division. You see, you jump several judges, senior judges, and then you point something far away. So you were hand-picking persons that must, in your view, must appoint you.
Yeah, that only involved two persons, and that would be my concern with an adult statement, and in the fact that my intention was to designate someone that has no ties with any one of us, and the judge who is out, on his way out, retirement, he's got no allegiance to any of the candidates. And I considered that to be a better option than someone who is close, very close friends with one of the candidates. I get your point when you say that it could create a negative impression, the fact that I've asked for the recusal of someone who's closely affiliated to Nadal, and the fact that the impression is created that I have intervened in processes insofar as I didn't designate the same person who did the shortlisting.
My point I'm making in this regard is that as a leader of the court shows for the position that we're applying that you lack judgment. You know, you lack judgment, and at times you have impulsive judgments. You just become, I mean, oh, he was some years, he was a member of NADEL, therefore cannot be
You already made that point, Commissioner Malema, and I just want to did I say, oh, Bosiam. Did I say, Commissioner Malema? You see, when you're troublesome, that's what happens. Your name is always on my mind. Commissioners, on a serious note, I just, Acting Judge President Goliath has answered this question from all angles.
So that the last
do you still insist on asking your follow-up questions on this one issue? I'm talking to the others.
No, I'm going.
I'm covered.
I'm going on this point. The last point, I'm on my follow-ups. Regarding that statement, what I've picked up, what is striking to me, is that the statement by your secretary containing those, containing those assertions was written on 26th of September. Your own response was written on 26th of September. That is, they were written on the same day. Am I wrong to infer that you were part of the drafting of that statement with your secretary. You actually assisted your secretary or you drafted with her because they were done on the same time and she would have received the comments from yourself. Would I be wrong? So that's
Yeah.
the last question.
I have informed her of that comment relating to her. I did. I did not sit with my secretary and assist her to craft a response. Her husband is an advocate, and I think he assisted her with that. I didn't assist her at all with that response. Actually, I just received the response, and I think I should have sort of studied it more, but it wasn't. I didn't write the response. Yeah.
Commissioner Mangen?
Thank you, Chief Justice. AJP, let's allow you some time to catch some breath. I want to converse with you a different matter.
No, she still has to answer. She has not concluded.
She hasn't, oh,
She hasn't concluded.
okay. Oh, then
Mr.
I can,
Boshoff
then I
was
can
still-
wait. Then I can wait.
Please, Commissioner Baloi.
Thank you, Chief Justice. It's a factual correction of fact. AJP, relating to the recusal of Mr. Njesi, you wrote to the JSC on the 18th of September. And the reason you gave is not what you're saying now, that you wanted him to recuse because of the deplorable statement or the statement that was made about your division. Your letter says, Nadel on the 27th of May issued a media statement in which it recorded its national executive had a meeting to call for appointment
Yes.
of a judge to be interviewed with you. And you say the statement was widely circulated. And then in the said circumstances, you say, I submit it would be inappropriate for Mr. Njesi to sit as a commissioner when it conducts interviews and to vote on the appointment. A reasonable, objective, and informed person would, on the above facts, reasonably apprehend that Mr. Njesi will not bring an impartial mind to the interviews and will not be open to persuasion in respect of this appointment. So, and that's really pretty much the end of your letter. So the reason that you provided on the 18th of September is Njesi cannot sit, Commissioner Njesi cannot sit through these interviews because he would be biased, or he's got a risk of being biased because they support a candidate. Not what you are giving us now.
Commissioner, the statement, when you look at that letter that you have quoted now, it cannot be looked in isolation. One must examine the statement. The statement called for an alternative candidate because the division is in disarray. And if that is a starting point, that is my main problem. Because an alternative candidate, in my view, the motivation for alternative candidates to say the division is in disarray, that is an incorrect assumption. And someone who's going to sit on this body is going to sit with that preconceived notion that the division is in disarray, and that is why an alternative candidate must be supported, and that is not something I can contest if that is already a preconceived view that someone holds in the appointment of an alternate candidate. So it was more about the content of the statement and the idea that the division is in disarray, which would then justify the appointment of an alternate.
All I was doing, AJP, was to put the reason that you gave us when we decided your objection or your request for recusal. This is the reason you had given us, and that's the reason on which we decided.
That is in order. I accept that because the statement was annexed and the Commission is fully alive to the content of that statement, so I will accept that.
Thank you, CJ.
Now, can we get to the second part of Mr. Boshoff's question?
Yeah. Mr. Boshoff, yes.
Sorry, AJP. CJ, can I just correct the first case I discussed was tapping Pygon trading. I think I said construction, but it's Pygon trading.
That's right, yes. The matter of Pangaka was raised at the previous interview, involved a postponement. Yes, I have erred in that case. I have conceded that I've learned my lesson in that case to the extent that postponement should not easily be granted. I think I've dealt with that matter in a previous interview when I was asked what did I learn. It was a matrimonial dispute, and of course one party was ready and felt that the other party was using delaying tactics. And I sat with a colleague, and we then were of the view that a postponement should have been granted because the legal representative was had commitments in a higher court, and that was the reason why the one party wasn't represented. So I concede that my colleague and I erred in that judgment. The other judgment, Paragon Construction, I take note of the judgment and the comments that were made in that judgment. Commissioners, I'm 19 years a judge, and my appeal record is very sound. And I'm saying this with regard to concerns raised by the Commissioner with regard to my intellectual capacity to be an example to other judges. I think my record speaks for itself. 19 years as a judge, what is it, 10 matters that's been overturned? It's not that.
Commissioner Matolo Lebu.
Now, thank you, Chief Justice. Good day, Judge Goliath.
Good day.
You know, I've been listening to you. When you started, you said you have an open door policy. The division is working well. Every judges are working well together. But as I listen to you, am I correct in saying you seem to suffer from lack of trust of your own colleagues? I'll say, I mean, the comments you made about Judge Sally, and also about wanting to get other judges from recusing themselves and formulating your own panel. I mean, how can you convince me that, and you said you are a communication specialist, that's what you said. But from what I've heard, you lack communication. You lack communication skill. You can't even communicate with your own colleagues. You can't even trust the same JSC that is interviewing me because you want everybody to recuse themselves. So in their deliberations, how do you expect me to say, this is the person to lead the division? Can you respond to that?
Commissioner, there was only one application for recusal that I made. So from my vantage point, it only involved that the president of Nadal take up a seat here based on that statement, which I have explained. It's the content of the statement that I had concerns about. With regard to the designation itself, I exercised a constitutional power, but I've noted the Commission's concern that I made that change because the Commission expressed the view that I should have left the person who did the shortlisting to represent the division. I have dealt with that I weighed up a judge who's very close to one of the candidates, vis-a-vis a judge who's on his way out and has no ties, not with me, with none of the candidates. We're not close, we don't socialize, nothing. The judge is on his way out. The judge acted in the Constitutional Court, an experienced judge. But I've noted the comments. With regard to communication, I do have an open door policy. Any judge who has a problem can come and speak to me about it, and they do. That is exactly what they do. I have one instance where a judge raised certain issues here at the JSC, and I've dealt with this. I've dealt with these issues that were raised, and I accept that there is room for improvement. I will accept that.
Commissioner Steinbeck.
Thank you.
Thank you, CJ. Good morning.
Good morning.
Acting JP. I want to go back to the Standard Bank judgment,
Yes.
because I think it's very important to characterize what you got wrong here. It's important because candidates should not be afraid to come here because their judgments have been overturned on appeal. High Court judges work under such enormous pressure, and to get those judgments out is very important, to get them out quickly. And if they get them wrong, well, that's what the appeal court is there for. And there are usually arguable points of law in most cases of any complexity. And it would be wrong to characterize how the SCA overturned your judgment on that basis, and why this judgment has been singled out. It's not a run-of-the-mill overturning of appeal. The court says you made two fundamental errors. You granted an order where there was no application before you. There was a non-existent application, and you granted an order. And at the same time, you ignored an existing order of court. Now, those are primary and fundamental errors. They're not arguable points. So in answering the question, this is not about other judgments you might have got right or errors the judges made. This is such a fundamental and serious error that, you know, the court says the High Court must be regrettably be deprecated in the strongest possible terms. It's an exceptional situation. And I wanted to make that clear.
Thank you very much.
CJ, before the candidate answers, can I please follow up on that point? Because that's the question I wanted to raise.
Okay.
So that we can save time. Good morning, Deputy Judge President. I think Commissioner Steinberg is raising an important point, because what the SCA was dealing with, there was a settlement agreement where multiple orders were granted. One of the orders that were granted was to withdraw the business rescue application. The other one was to postpone the liquidation application. So at a later stage, there was an answering affidavit that was put up, and the matter was argued at a later date. Then what the SCA is saying, when you had the matter, you did not take into account the fact that there was a settlement agreement where the business rescue application was actually withdrawn, but you proceeded to grant a business rescue application. That is the application that the court is saying it was not before the court. And I think that is where the fundamental challenge is. Thank you very much, CJ.
AJP?
Yeah, Commissioners, I've noted the comments made. I have erred in that judgment. From my vantage point, the business rescue application was revived after the fraudulent agreement, but I accept the SCA's comments ruling that the application was non-existent because I approached it as a fresh application. But I've noted the comments and I accept that I have erred in that regard. Yeah.
Commissioners, I'm going to urge you to please think carefully before you raise your hand. We've been interviewing this candidate for almost 3 hours now. Do you still want to put your question, Mr. San? You were the first person to raise your hand.
I was, in fact, but I think in the interest of time, a number of issues have been covered.
Thank you. Commissioner JP Mulambo.
Good morning once again,
Good morning.
AJP.
Good morning, JP.
I'm surprised you shortchanging yourself regarding the initiative you've taken as AJP for your court to be digitized. I think you should have mentioned that more strongly. You even sent a team to go and observe judges and court staff. Am I correct?
That's correct, JP. I'm passionate about improving the efficiency of the courts, and digitization and innovation is close to my heart. So the court is fully trained.
Yeah.
we are out of our starting blocks and we are expanding the training in Cape Town. We're working on our practice directives.
Yeah. You've mentioned
Yes,
that.
the Western Cape High Court is drowning in paper, so it's very much needed. And yes, I am passionate about that project.
Yeah.
Yes.
I just want to explore two things with you quickly, and you don't have to be to give a very long explanation about each in the interest of time. One is, you've mentioned several times that the 80% of the judges are doing criminal work, or were doing criminal work, and 20% doing the other work. But I'm not sure if I heard what your vision is, because from where I sit, there's always a set number of judges that do the criminal roles, and then there are the other judges do all the other work areas. I don't think I've heard you what your vision is as to ensuring that there's an equitable spread of judicial resources that attend to the work that come to the court. Are you able to give that clarification? What's your vision about correcting that?
Well, obviously my vision is for the Western Cape High Court to be a united bench, to be accessible to all, and to be a leader in efficient, effective and expedient service delivery, but through the means of digitization, which will then streamline processes and make the court more efficient and more
Can I
effective.
stop you there? I'm talking about this issue.
Of 80%
Yeah,
in crime,
80
yes.
and 20%,
Yes.
yes.
Normally, we would allocate criminal matters to 12 or 13 judges. That is our normal formula, Commissioner. But because of the backlog, we have many matters that is part heard that needs to be completed. So even if you take a judge, you can take a judge out of crime only once they have completed the full hearing. The Western Cape Division is in a unique situation that most of its matters involve multiple accused. So the trials do tend to take long. So my strategy was to finalize backlog, to finalize part heads. And during that phase, 80% of the judges were in crime. We also have ad hoc judges coming in to finish their crime. And that is why I had to introduce the pro bono project to assist with the civil load. So what the strategy is to get more judges in the civil pool. But as we stand currently, we have 33 parted matters, that is of which 14 is in sentencing stage. So the idea is to have only 13 judges in crime and the rest in the civil pool. While we are finalizing, we're at the tail end of working away the old criminal matters. We're at the tail end of that. We have 102 matters on our pretrial roll. So it's a matter of balancing how many new matters are going to start in consultation with the NPA so that we can go back to our normal figure of only 13 judges in crime. So what can happen is that you have 13 judges in crime, and then you have judges who are partial civil and partial crime. As I've mentioned, some of the cases are in sentencing stage, waiting for reports, probation office reports, or any other outstanding issues. JP, in terms of going forward, the civil matters are being attended to by virtue of the special Friday roles that I've introduced so that the civil workload does not suffer. The RAF matters are being managed and mediated, which creates slots for civil matters to be brought forward, to be finalized. So I am dealing with the fact that there are more criminal matters running. I'm dealing with the civil matters in that way.
Okay.
And in so doing, that concern that there's not sufficient manpower to attend to civil matters is no longer there. I've balanced that out with the pro bono project and the Friday project and the RAF project.
Okay. Thank you very much for that. I don't agree with you, by the way, when you say the running roll method won't help you.
The continuous roll.
Yes, continuous roll, yeah.
Yeah. Continuous roll is an advantage, JP, because if you can focus on one matter and let it run through, it is fine. But what happened with these part-heard matters, sometimes the judges get stuck in the middle of the matter because the counsel is involved in more than one matter, and counsel must then first be in one court and then in the other court, and I'm specifically referring to legal aid counsel here. So sometimes a matter must stand down while the legal aid officer completes another matter. So there's this piecemeal finalization that then destabilize the continuous role. And that is what we are busy working away now, so that we can actually go back to a continuous role. That is the ideal, JP.
Okay. My last question, CJ. One of the issues raised by Judge Ali is your allocation patterns.
Yes.
And the point she makes is you allocate more complex work to acting judges instead of allocating work to permanent judges. I've come across one case. You sat in a Scalabrini Home Affairs matter some years ago, and there's another one that was decided in August, I think this year, by an acting judge. It's a matter that involved issues that have already been decided by the Constitutional Court, by acting judge is it Manga, if I may pronounce it.
Manka.
And I ask myself, this was not an easy matter because it had to do with declaring certain legislation unconstitutional. And it touches on matters that have been dealt with by the Concord and some of them by a full court in Gauteng. So I ask myself, how was this matter allocated to that acting judge? And to be fair to you, I look at your lineup of people who want to be judges in the Western Cape. This person is not there, and I don't know how many times she'd acted in your division to get the nod to deal with that matter. So I'm raising it in the context of what Judge Ali says. Are you able to deal with it? Do you know the matter?
Yes, I'm aware of that, JP. Allocations in the division, it's purely done based on availability. And the Western Cape division is a very busy division. So the judges, specifically in the civil pool, they are very busy. And sometimes you get matters that should then be allocated as an early allocation, and that was one of those matters. It was an early allocation. And it's a lot of reading. So because the judges are so busy in the civil pool, what happens is dates were allocated to that specific matter. Remember, I don't allocate the dates. So when the file comes up for allocation, I can only look at my register to see who is available to hear that matter. And if someone outside the division, if an acting judge or a pro bono judge is given that matter, it means that no one was available in the division to do that matter, because that is the starting point, is to get, if you know it's a high impact matter, is to look for a judge within the division. So sometimes these early allocations also come up a bit late for allocation. It must come up at least 10 days. That would be 2 weeks. It's 2 weeks, which means 5 days of the week plus the previous week 5 days. So it comes up 10 days before the time. And that is the time when you would actually assess the availability of judges. Yeah. Okay. And, but the recipe is first see who is available inside the division before you would allocate it to someone else. It's only if there's no one available inside that it would go to an acting judge.
I see.
Outside, yes.
That tells me that there's no gatekeeping role that the leadership of the division plays when it comes to these complex matters, because you would jealously guard the jurisprudence coming out of your court, and you would not simply allocate to anyone. I do that with my DJPs, and we allocate 3 months in advance, and we know how to allocate those matters. So it sounds like in the Western Cape, it's based on availability. Am I correct? That's your answer.
That is a main consideration.
Yes.
What one can do is change the date, ask the parties maybe to shift the date, so that you can then allocate it to someone in the division.
Okay,
Yes,
thank you.
that
Thank you
is
very
what
much.
one can do.
I've got no further questions.
Thank you very much. Commissioner Hassan?
Thank you. I actually think that there is a matter that wasn't covered in some of the questions that were already posed. AJP, I'm over here, Commissioner Hassan. Thank you. I just want to ask, maybe related to some of the elements around unity. I think there is some perceptions that in the Western Cape Division there are camps, and I'll say perception to be fair. So I'm very interested, AJP, in this process of building division and, of course, creating stability. And I'm going to ask a difficult question. Should you be unsuccessful today, AJP, would you be able to support and help build that unity with a different candidate at the helm of the Western Cape Division? Because we've heard numbers of things of not visiting different chambers, the tea room, there's a lot of rumors, I'll say it like that, a lot of rumors that are rife around the disunity there. So I'm very interested, AJP, what you would do should you not be appointed at the helm of this court. Thank you.
Commissioners, I am the constitutionally appointed Deputy Judge President, and my role as the Deputy Judge President is to support the Judge President. And that is exactly what I intend to do. That would then be my mandate. And when it comes to the appointment of someone else, of course, I need to be deferential, and people have different leadership styles. So I will then navigate my way around that and just provide the support as my current position dictates.
Commissioner Gosa?
Thank you, Judge. Good morning, Judge.
Good morning.
My question just relates to what JP Malamba was saying. And in your interview in the beginning, you said that you have established but also sit on many committees within the division. And I was wondering, does this, together with the burdensome job of managing a division, allow you to also sit on complex matters?
Well, initially when I managed the division on my own the first term, and I did quite a bit of court work during that term. But later on, as the time progressed, the administrative burden, due to the administrative burden, I had to reduce the time I spent in court. But yes, as a leader, you do have time. You can prepare your diary accordingly and do sit in certain matters. I think that the slap judgment that I did, I think I was in my position already when I had the slap matter. I heard matters on trademarks while I was AJP. And of course, I fulfill some role in mediating family matters before it gets allocated. I mediate all family matters and matters involving children. So yes, I do have time for judicial work, but it needs to be in a structured way, because at the end of the day, you also need to do some court work to sharpen your skills. And as a leader, you also need to set an example and go to court in certain matters.
Thank you.
Okay. President Molemer?
Yes, thank you very much. AJP, just a follow-up question. You said you managed the division on your own upon assuming your duties for the first time as AJP. you managed the division on your own. Did I understand you correctly? In other words, there was nobody acting as a DJP?
That's correct.
What motivated that decision, if I may ask? Bearing in mind that you took over at the most difficult time, and one would have imagined that you'd have a lot of administrative responsibilities. Did you not consider that it would maybe be wise to also have somebody helping you?
President Molamela, there were always senior judges, and still there were and is senior judges that you can always approach to assist you, whether it's with the RAF court or with criminal matters, etc. My strategy, the first was just to run the division on my own and do a wellness check and put certain things in place and bring things together, and then appoint, during that term, I then identified someone to act as the deputy. For me, my strategy was, because I was the DJP, and I knew more or less how the division functioned, I could make strategic decisions quickly without having to consult someone at that time, just to put the system in place and make sure that the most important things are done that needed to be done. And during that term, I then had discussions with different judges to make an assessment of who has the necessary skills to assist me in the running of the division.
Thank you, CJ.
Thank you, President. Commissioner Mangen?
Thank you, Chief Justice. I've got two questions for you, AJP. One is just an invitation for your comment. When Judge Gamble interacted with you regarding acting judges, you said something to the effect that you are unable to find capable black acting judges. What did you mean by that?
No,
in Cape Town.
In Cape Town. Thanks for the qualification.
No, I indicated that I look outside of the province as well. That's what I said. I look outside of the province. We have black acting judges from Cape Town. That is generic black. We have, if not all of them, are from Cape Town, except for 3 African women specifically. I'm referring to women that I invited from outside of the province. So there are generic black acting judges. I just made the point that I don't limit it to Cape Town only, that I do go outside, because in Cape Town, there's a lack of African female acting judges. That is the problem. We do have, but it's just 1 or 2 African females.
And in your vision that you outlined, I did not hear you outlining in detail what plans you have to bring in more capable black acting judges.
Well, I have started that process by looking beyond the province. During my reign, 29 women acted in the division. The division is fully transformed in terms of gender, but not in terms of race. And I think there is a need to appoint more African women on the bench. I have embarked on a program to appoint more black women, which I did. I think last term we had more female or women or African acting judges than in any other group. So that is work in progress, and those judges are currently in training. In the total of 29 women that I had, I see 8 were black, 8 white, 7 colored, and about 5 Indian of the 29. I have mechanisms in place. I deal with the structures. I am encouraging African women to make themselves available. I think that is the group where the Western Cape can improve in terms of the diversity pool. So I'm actively pursuing that agenda and actively approaching African women, which I did.
Thank you. My last question, AJP. By my calculations, and you'll tell me if I'm correct, you said you were appointed DJP in 2016.
That's correct.
And that makes it 8 years. And the last 2 years of this 8 years, you were the AJP.
That's correct.
In these 8 years that you were the DJP, where you were required to work with the then JP, obviously under what you call difficult period, did you get an indication that you've got the support of your colleagues on the bench in your work as a DJP? Because if that was the case, why would, when an opening comes, so many of them avail themselves to do what you should have done in 8 years?
I think that is the aftermath of the issues in the tensions. Obviously, I'm not entitled to the position of Judge President in the division, and I think anyone else is free to make themselves available. As DJP, I had a cordial relationship initially with the Judge President. I did receive the support of all the judges in the division, but when the problems arose, it is so that it created division in the division in terms of split or little groups. My task over the past 2 years was to try and overcome that bridge, and that's why I introduced the tea room and regular meetings, etc. I tried to normalize the functioning of the division by committees being active and the tea room fully functional, meetings held regularly, interaction between judges. Yes, more can be done. I'm not saying it's a perfect situation, but as DJP, I did get the support of the judges in the division. I think it is normal in the aftermath of the situation between myself and the Judge President that there would be challenges to navigate. And for the past 2 years, that was my goal, to navigate those challenges and build bridges and improve where I can and try and create an environment that is conducive to collegiality, which there is currently. The fact that many judges make themselves available, I think it is their right to do so. No one is entitled to that position, and that is just the reality of the matter. That does not mean that I didn't perform my functions as the deputy or as the AJP. As AJP, I was a caretaker, and I'm satisfied that in my position as caretaker, I've stabilized the division, and going forward, this commission will then decide who is going to take the division forward, and it most certainly can be any of the 8 candidates who are all entitled to make themselves available.
Thank you, Chief Justice.
Professor Marumokgai?
Thank you very much, Chief Justice. Good afternoon again, Judge Goliath. And I think it is really important, notwithstanding the discussion that we had on that Supreme Court of Appeal case, to state that you are actually a very good judge, forensically. I think that must come out very clearly. And you have penned some of the most important judgments, especially when you are in the Constitutional Court, the Rahube judgment, the veterinary medicine judgment, and the others. You have actually done very well, and I think that should come out very clearly. And again, there is one judgment. I want to take you to page 31 of your document. There's a judgment that you penned, which is one of the beautiful judgments that you did.
that deals with trademark law. You done that quite a long time ago in 2015. And that judgment is one of those that really tried to illustrate the differences between trademark infringement on the one hand and the law relating to passing off on the other. And I think you did very well on it. There is something that comes out, though, from the judgment. I know it was a long time ago. I'm not going to bore you with the details, but I just want to ask you a general question in relation to trademarks generally, and Section 34 of the Trademarks Act, which you deal with quite competently in the judgment. When I read the judgment, I got a sense that, can one say that the fact that the proprietor of a registered trademark fails to demonstrate significant consumer recognition be a defense to a trademark infringement claim? Because in the judgment, when you are dealing with Section 34, you quite correctly show why the person who's claiming trademark infringement should not succeed when you are comparing the two marks. But I'm just curious to know that if you fail as a person who says, look, this is my trademark, and it has been infringed. If I fail to demonstrate that there is this general recognition by the public, can that be a sufficient defense to a claim of trademark infringement? And I don't know the answer, I'm just asking.
Yeah, look, I've written a number of judgments on trademarks, but if someone can't show that its business is associated with a trademark, it can become challenging to actually stake its claim if it did not use that trademark, and then that business must be associated through use of the trademark. It can become challenging. I don't think it means that you cannot lay claim to the trademark, because there may be other factors involved that may allow you to claim the registration of the trademark as your own, because it could have been used for some time, and then it was lying dormant, and then you want to revive it, and then someone wants to come and say, but your business is no longer recognized through use of the trademark. Yeah, I think there's no probably definitive question, but it will just make it more difficult to show that your business is associated with it, but it does not necessarily mean that you're going to fail to protect the mark.
Thank you very much, Acting Judge President. Thank you, CJ.
Thank you, Prof. Commissioner Malem, your hand was once up. I don't know if you still want to put your question.
Just a quick one, CJ. I always hear these councils here, where every time a decision is made, they say it has to meet the rationality test. What is your understanding of a rationality test?
When you exercise public power, you must exercise public power in a rational way. In other words, if it's the legislature or the executive or any public official, if they exercise power and make decisions, it must pass the rationality threshold, because all public power is subject to constitutional control. And the rationality threshold is very low to meet. So, for example, say it's socioeconomic rights that's at stake, and a department is being sued for not providing sufficiently enough service. The judiciary cannot interfere with polycentric decisions that's made by the other arms of state. And why I'm saying that is, if the reason for a policy or a decision meets the rationality test, that is sufficient, and the threshold is quite low, because all decisions that are made there must be a rational connection between the decision made and the purpose for which a provision was enacted.
So in exercising public power, where as acting JP, you have the right to appoint or designate. In exercising that power,
That's correct.
you look at the reasons and say it's a friend of so and so. Is that a rationality? Does that reasoning meet the rationality test, which is the lowest? I'm happy that you are saying the rationality test is very low. Low as it is, do you think the reason of in the exercise of public power to choose a designate, you say, no, this one is a friend of so and so. Does that meet a rationality test?
Well, the rationality threshold is low. It is so that someone else may feel that my reasoning does not meet the rationality test, but the threshold is low. And someone else may say that I would have exercised my discretion differently. But the fact that someone says, I am inclined not to agree, I would actually have exercised my discretion differently, it's not sufficient reason to say that someone else's reason is totally irrational.
AJP, I'm not asking you about someone's decision. I'm asking you about your decision. Does it meet a rationality test? Because I'm going to argue that your reasoning does not meet a rationality test. And as a judge who's supposed to be objective, you must answer from that platform from an objective point of view and be honest with this panel. After the engagements we have had with you, in all honesty, not whether someone else will say it meets the lowest expectation or not. In all honesty, after the exercise we have gone with you for almost 4 hours now, do you think that decision meets a rationality test, which you must meet when you exercise a public power? The reason why in the exercising of the public power, you have to meet the rationality test is to avoid abuse of that public power. Because what you did is an abuse of that power. Because it doesn't meet the rationality test. But in your own standard, as a leader, as an aspirant judge president, do you think, on a hindsight now, that decision you took, based on friendship of people, does it meet the rationality test?
Commissioner, the issue is not necessarily about the reality, it's also about perception. So it is so that from a certain perspective, one may believe that it does not meet the rationality threshold because the mere connection to a friend as one of the candidates may be viewed as insufficient reason to designate a different alternative.
AJP, CJ, please, I think we've been long here. All I'm asking is, does her decision, after all of that, meet a rationality test? What she's explaining, she said it before. We've heard that. We just want to know if she says it's yes or no, that's the answer. But I must not go and second guess her in the deliberations.
Commissioner, I'm trying to explain that the fact that someone is closely connected to or a friend of one of the candidates may not meet the rationality threshold in certain quarters. I can understand that. From my perspective, in designating an alternate, I looked at the matter clinically and said, what would be the best option? A designate who has absolutely no ties with any of the candidates, including myself, or someone who is connected to one of the candidates by virtue of friendship. And I then took the decision that it's in the interest of today's proceedings to have someone who is completely disconnected to all the candidates, and that was my motivation. And Commissioner Malema, I hear you that you want a yes or a no answer. I hear you want that, but I need to explain to the Commission that I was sitting with two options, and from where I sit, I made the most rational decision to choose someone who has no connection with all the candidates.
Therefore, it meets a rationality test.
Excuse me?
Therefore, it meets a rationality test because you made a rational decision. That's what you are saying. I'm not a lawyer. You must simplify it for me.
Yes.
Your decision met
Yeah.
the rationality test in your corner.
Yes, the threshold for the rationality test is very low. Someone else may feel that the person who is connected to one candidate may indeed be suitable, but someone else, someone in my position felt I would prefer someone who is not connected at all to any of the candidates. And that would, for me, be a more rational decision, simply because a designate who is not connected to anyone will be able to fulfill their function better, because it's not only about reality, it's also about perception.
I give up, CJ.
That is the answer, Commissioner Malema.
That's what I'm saying, I
Think
give
what
up.
you will. Very last question, Commissioners. Commissioner Lekhanyan.
CJ, thank you so much. Very quickly. Good afternoon, AGP.
Good afternoon.
AGP. Just to check with you, who appointed Judge Gamble as the AGP today, for today?
I designated him on the 8th of August.
Yeah?
This year, I did the designation.
It was yourself.
That's right.
Did you do it in consultation with the Chief Justice?
No, I didn't do that in consultation with the Chief Justice. The shortlisting involved the former Chief Justice, not the designation.
The cogent logic that you advanced on the matter of Nojesi and Judge Erasmus, does it not apply in the case of Judge Gamble, who must be designated by you to come and participate in an interview where you are a candidate?
No, it does not apply.
Thank you so much.
Because in the first instance, Section 178K grants that power to designate, and I have exercised that power in a manner where I thought it would be best if someone represents the division who has no ties with any of the candidates on the list, not even with me, absolutely no ties. Judge Erasmus was designated to attend to shortlisting by the Chief Justice, and when the shortlisting came out and I saw that there's someone's name there that's closely linked to Judge Erasmus, I then elected to exercise my constitutional power in a manner where someone who is completely neutral to all the candidates are appointed, and someone who has no connection with any of the candidates at all. It's not my choice. I'm not a friend of Judge Gamble,
No.
and he's due to retire in November. There's no connection between us.
Commissioners' hands still keep coming up, and I've been very inconsiderate with this candidate. It's chasing 4 hours now. She has not even taken a break. We've been walking in and out, relieving ourselves, getting coffees, while she's been sitting there answering all these hot questions. I just want to say this for the last time. Please think very carefully if you really want to answer, if your question will take this process any further. Maybe put it that way. Do you insist, Mr. Boshoff? All right, thank you. Thank you very much, Acting Judge President
Thank you very
Goliath,
much.
and
Thank you very much to all the commissioners. Thanks.
you're excused.